This is in regarding to heat up. Villagers are utilizing the land. Petitioner has anyhow managed to get the land in his favor. That's a government property. Now, by virtue of this pendency, he's obstructing the village for ingress and
according
doing puja and
fix the
function.
date. So that we can verify that accordingly put the date. Because it would be the valuable time of the court would be set. Please give it.
Yeah, system intelligence or urgent matter is there.
Please verify in the launch hour.
No, I have enclosed, there is a similar order has been passed.
So all like
Then
this.
what is an urgency?
No, that is similar to MGQ matter. No, that 31st they have closed my shop. That is not. No, two shops they have closed.
Appointment of a member of State Consumer Redressal Commission.
Please give it.
My lord, let it tomorrow.
Please pass on those memos.
Otherwise, it will be interrupted.
Let us see.
May I make a mentioning, my lord?
Previously, two writ petitions without disposing of the direction of the honorable single judge. They have filed another writ petition and has got the case allowed.
Please give the memo.
I got 40 shirts of item 1, 3 weeks time to file counter. This is something of the petition.
What do you want?
3 weeks time to file counter.
Let it be called.
In the matter.
May I mention,
Just remind us.
may I mention a matter, my lord? Through VC. My lord, may I mention a matter?
On a virtual mode.
Yes, my lord. May it please. My lord, this is a matter which was pending before Justice R.K. Patnaik's court, my lord. It was listed today to be taken up as a specially fixed matter. I have already given the memo. In the meantime, due to change of roster, my lord, it is deleted from the list, my lord. Now, this is a writ petition, my lord, against the Bhubaneswar Municipal Corporation.
No, whosoever is in the charge of those matters, so mention before the honorable judge. Why are you mentioning before us?
I'll do that. I'll do that. Obliged.
List item number 1.
In this case, the writ application filed, telling me the order of minor single judge, page 90. Page 90.
90. Yes.
My lord, previously the writ application was disposed of with a direction to PPDOCL to consider my case. I was engaged, I was a lady engaged with a legal assistant, the executive legal.
But sir, you were engaged through a franchising.
Franchise.
Now the franchisee, there is a contract. And if the contract has come to an end or a contract has then what is the right which you have claimed
No, my
against
lord.
your principal?
No, my lord, after that, once the PPCOL taken over the charge.
Contractual.
Yes, that is the contract, my lord. I am 100% agree with my lords. But once the PPCOL has entered into a settlement with all the franchise, that whatever of employees who have not been engaged shall be engaged in the PP. That is, my lord. Kindly go to the page number. Yes, ma'am. Page number 82. May I read, my lord? Last 3 lines. It was explained that over a period of last 10 months, PPTOCL has ensured employment for the earlier local employees working on the various
You come to page number 3 of the impugned order. Come.
Yes, ma'am. Page number
Come
3.
to the later dated 29/1/2021 of the general manager of TPO. CODL.
Just a minute.
That is quoted in page number 3
Yes, my lord.
and the last sub-paragraph in our personal hearing. Just read it out.
Page number 3.
Yes,
Ye-
3 of page number 6 of that order.
Impugned order.
Yes.
Yes, my lord. The petitioner is a law graduate.
No, that is in our personal hearing.
What is the current? Yes, my lord. Yes, my lord.
And the another franchisee has come.
Yes.
And the another franchisee say there is no.
In our personal hearing.
Yes, my lord.
Please place it there.
In reference to the aforesaid cited subject and pursuant to direction of last paragraph. In our personal hearing, you had also reiterated the same fact and requested to consider your case on humanitarian grounds. It is to inform that CPCODL is a separate organization, has not taken over and acquired by any states of FIDCO, nor has entered into any understanding or agreement of any nature to involve the employees of FIDCO.
So,
What may, if it is an independent organization
My lord.
and it is governed by their own rules,
Yes.
then how can you impose something which has been done by the past
No, my lord.
franchisee?
My lord, page 82. My lord,
Now, suppose if, kindly visualize the situation, suppose if there is any violation of the mandate which was given with the principal,
Yes, my lord.
then it is a matter between a principal and that franchisee. What right, legally enforceable right you have? That is what our question is. What legally enforceable right you
My lord,
have?
they have, my lord, with the due applies, my lord, they have entered into a settlement with all the federation and employees to take back all the employees working on the different establishment and different franchise.
they have stated very categorically that they have not taken over, acquired any stakes of the FEDCO,
Yes, my lord.
nor has entered into any understanding or agreement of any nature to induct the employees of FEDCO.
My
So
lord.
very clear.
My lord. My lord.
So,
But there was no necessity of filing a representation. My lord, the direction last para, my lord. My lord, page 98.
even if that has been done, because you say
This is-
the earlier direction was to file a representation before the FEDCO. You came up that it has been taken over by the TPCODL,
My
so
lord.
modify the order.
My lord.
Accordingly, the Honorable Judge passed that order.
Yes.
So the fault lies with you.
No, my lord.
Very
My lord, I am clarifying that. My lord, the para, last para, my lord, 98. 98. Therefore, five.
Is it not the case that earlier the direction was passed to dispose of the representation by the FEDCO?
By the FIDCO and subsequently it was added.
At your instance, you file an
Yes,
interim
yes,
application
yes,
for
yes.
modification of that order,
Yes,
and
ma'am.
in place of FEDCO, it should be TPCODL.
Yes, ma'am.
Accordingly, the order was modified. Now the TPCODL says that we have not entered into any agreement with this FEDCO. There is the question of imposing them to give you employment.
My lord, TPCODL has taken all the staffs, all the employees engaged under FIDCO. My lord, that is the 82, page 82.
It's a disputed thing.
Page 82, my lord. The settlement.
Mere direction to consider the representation does not confer any inchoate right into you.
My lord.
And once they have taken into consideration by passing a reasoned order, then you'll have to impinge the impugned order
My lord.
that it is either unconsignable, it is unreasonable, it is irrational, and your contractual legally enforceable right exists. We are still at loss to understand that what is a legally enforceable right you have.
My lord, after that order, I filed the writ application.
True, but mere filing a writ petition does not mean an order to be passed in your favor.
But my lord,
You have to convince the court that you have this is your right first, which is a legally enforceable right.
Yes,
second, and then this right has been violated
yes,
or infringed. These are the three things you'll have to prove. Still, we are at loss. What right you have? What is the right which is legally enforceable against the TCCODL or what is? And what wrong they have committed? It is still at loss.
My lord, if that is correct, my lord, once I have filed the writ application was disposed directing me to file a representation. Again, that case has been disposed with a similar light, my directing me to file another representation. Because if there is no meaning, what is the necessity of directing the again to consider my representation? that need to be.
That you are correct, that this writ petition ought to have been dismissed
Yes.
instead of going there. So you want a dismissal of your writ petition. We'll dismiss it.
No, my lord, I am.
Don't worry, we will modify the order and dismiss the writ
I am
petition.
submitting before my lord. I am submitting before my lord. My lord, this is the case because the person, the lady was serving here 6 years.
I understand, but
So-
this is a contractual employment. If the contract has come to an end, and if the contract has not been extended, can you enforce that contractual right? I'm just asking you what contractual right you have.
My lord, 82, page 82. My lord, then go. Page 82.
82, we have gone through it. That does not really.
That is the settlement, my lord. They have got.
Wait, settlement is not binding.
It has to come on one day. Because of clarifying the order.
This is no. See, no order. At the top. Page number. What is the page number? Order.
24/3, no? No, this is the order passed.
Order dated 12/9/24 is under check. So that is at page number 12, sir, in the top and reading page number. Why the page number is not coming?
This is.
Sir, यहाँ पर आता है 12 page. Yes.
No, no.
That is WBC, sir, not the WP.
I'm
The info
Base 90 starts on 80, profit to 93.
Page 90.
90s.
Order
Yeah, this is-
12/9.
This is 12/9/2025.
Well,
18 है यहाँ पर आएगा सर. हाँ यहाँ.
No, this is
नहीं,
not.
उसके बाद. हाँ ये.
Yes, WTC is.
My lord, let it come 1 week after. I said,
No, no.
I said, because there are.
There was a difficult questions are put
There are
not
no decisions.
currently in adjournment, no.
My lord, there are two decisions
No.
also.
Shows that this is a contractual.
Yes, my lord, this is the Rashmi Rekha Das, this has been decided by the. Court.
Show us. Person.
Which paragraph, which?
Last one.
No, this is not the way to place a
My lord,
judgment.
sir, for that reason, I want 1 week.
No,
What?
1 week. I shall clarify that.
you are
And
placing
No,
the.
that was the case of a Uma Devi 3.
no.
That is what is.
Then my lord has taken into consideration. My lord, the last paragraph. Uma Devi decision has been taken into consideration, but plan.
No. This is what is said that that if the services of a particular employee is being utilized for a considerable period of time, then in that event, it was said that there should be some consideration which should be there. And the question is that in over the V3, the question was anybody who is appointed illegally have no rights legally enforceable. If he has been appointed irregularly and he is working 10 years or more without any order of the court or something, paragraph 53 of the
Yes.
Municipal.
Wonderful.
Then in that event, one-time measures have to be adopted by all the state to absorb them. And this is reiterated by Justice Ravindran in ML case, subsequent judgment. Now it is again reiterated by Justice Vikram Nath in a very recent judgment of 2025. That it says that one has to take. What is your right? You are not appointed by a government organization or an autonomous body or a state within the meaning of Article 12. It is the franchisee with whom they have the contract, who has employed you. Now that franchisee says the contract has come to an end, what right you have? A perennial right. Is not permissible. Come on. I think I should restrain from asking any question.
No, my right.
Otherwise,
Let it come
all
tomorrow.
that
I shall
adjournment.
clarify and I shall submit the documents. My lord. Let it come.
What's submit?
That judgments are there.
These are the judgments you are relying on.
And they are settlement
definitely
also.
take into consideration this judgment.
And there are settlements also. Then I can cite that I can submit the document.
This you are in a mandamus appeal, sir. Whatever the document you have produced before the writ court, now you have to rely upon that. Can you rely on a new document?
My lord, one submission. My lord, let that case may be remanded to the single judge to adjudication on merit.
No.
That would be better.
Then order 41, 23, 23A, we have to assign a reason that why we are remanding. The reason has to be assigned. We do not find any reason as of now. Give us a reason, we are ready. No reason.
My lord, let it come tomorrow. I shall.
What for? No, we are disposed.
No, my lord, I shall submit.
We agree with you. That's a wrong, that's a final order. The ultimate decision is not correct. Why consideration?
My lord,
Have
that-
been dismissed or the writ petition ought to have been dismissed.
My lord,
What consideration?
my lord, one submission is that there are 400 employees working, waiting for the appointment under this by virtue of stay order that continue. Because this
The
judgment,
franchisee has said that we do not say that we will not, but if there is any vacancy,
my lord,
the preference would be given to these employees. So that is what the franchisee has.
my lord, one submission is that in my case, it will be dismissed.
Perhaps,
My lord, if my case will be dismissed, it will be a precedent for that. My lord, let it come tomorrow.
we will write one, that it will not be treated as a precedent.
No, my lord, that would not
We'll
be,
write one line.
because there are several cases pending.
Don't worry, we will write that it will not be treated as a precedent.
No, my lord, I am agreeing with my lord's view. But
So you will not stop and ask arbiters to dictate the order.
my
You
lord,
will go on arguing and arguing.
I may permit to withdraw this.
By the accused order, the permitted to approach the general manager, given the credential of the TPCO from the respondent of the two hearing. With a comprehensive representation. Within time. Such predictions has been passed in a mechanical manner without adjudication of a right having conferred upon the argument. And therefore, it would simply encourage the litigations to remain in the docket of the court or to be filed in the court. And therefore, such order warrants interference. At the hearing of the certain queries were raised to the appellate. And after realizing the difficulty in answering the same, the prayer was made to withdraw the instant decree. Though several orders were passed with the instant decree, but we do not find that any benefit has been availed of. That orders pass simpliciter for simpliciter directing the parties to produce certain papers. Since the appellant does not intend to proceed with the instant decree, the appeal is dismissed for non-prosecution. Dismissed as withdrawn.
My lord, I said approach the labor court, my lord.
Without granting an appeal to file the self appeal against the identical law.
My lord, we liberty to approach the alternative remedy. I understand.
That is already provided.
My lord, without because it is pending.
No, it is because of order 23.5. No liberty.
Case admission item number 2.
Yes, sir. Why not?
This is a matter where the appellant, who was a petitioner before the single bench, yes, of course, he's been granted a relief of first rupees 1 lakh. Your Lordship, the fact of the matter is this, that somewhere in 2010, his loans were paid off and he applied for the return of his title deeds.
That's true, but now they were approaching a different forum because now they have come up with a bill that I think that is lost somewhere in the transition.
Lordship.
So the compensation was awarded to you.
Yes, Your Lordship.
Now the difficulty is that the original title deed is not available with the bank. And if it is lost, then what more? Because it's a registered document.
Absolutely.
You can have the certificate copy from the registrar or the registering authorities are there.
The RBI has thrown some light on this.
That is what is there. They have to keep it. Now there has been a lapses, there has been a negligence on their part.
No, there's a little more. If Your Lordships, can I just place that RBI guideline? Your Lordship, in fact, in that guideline.
Visualize, but you are talking about the RBI guidelines which you have made 5,000 rupees per day per the composition. Now they say that it is lost. It can never be retrieved. So for whole of the life, you will continue getting 5,000 rupees per day.
No, that's not what the guideline.
That is what
May I
I'm asking.
No, may I just, that's why I wanted to read the guideline.
No, I have seen, but they have said that they are lost. They are taking care. There was a proceeding there in the civil court. They wanted to have.
Yes, they said that they are going to, the guideline says that's the bank which is going to get a copy. The reason why I'm insisting, of course, it's a very typical case. The man is extremely old. He does not have anybody really to help him out. So for him to go and get a certified copy is almost next to
So you
impossible.
want a bank to take out a certified copy?
Yeah, Lord, so that's there in the order as well, of course, and that's there in the RBI guideline
So
itself.
where is the difficulty?
Until that time, the bank is liable to pay 5,000 rupees per day. May I just place that?
That document has been executed between X and Y. Suppose Z applies for the certified copy, whether he will get it.
Your Lordship, that's what the guideline says.
Or they are the two private individuals.
Your Lordship,
That was deposited. So if you want that bank should apply for the certified copy, they may face difficulty that who are you in here?
Your Lord, all that they have to do probably take an authorization from this particular evidence.
I am not applying for the certified copy. They have lost a document.
They've lost a document.
That means a return that document.
Yes, Your Lordship. Even a no due certificate, everything was there on place.
That order, the order of the license is there.
No, that is not there, but the no due certificate is there, which Your Lordship should find.
Certificate they can keep, but about this particular document, which you want that either this should return, the amount has been awarded for the compensation amount has been awarded.
By the single bench.
Lump sum amount.
Yes, Your Lordship.
You just
By the-
want that in place of that lump sum, 5,000 for pay basis.
That, yes, that was the prayer. However, Your Lordship, I think at best the appellant would be entitled from December 1, 2023 onwards only, at best, if I have to draw some.
So the applicability clause is
Yes,
there.
yes, Your
It
Lordship.
says
I have to be
applicability
fair,
for
yes.
a particular date.
Yes, Your Lordship. So I don't think my, this appellant can go before that date.
No retrospective operation.
No, Your Lordship. I do not see a retrospective operation in that because they say that due, it becomes due only after that date. So even if I have to draw a little persuasive value from it, that's the only limited thing I can do.
After this order was passed on 8/11/2024, did you approve the bank that please return?
Yes, yes, Your Lordship. It's only, only, I think, last week, the bank decided to pay that 1 lakh.
No, that is all right, but have you approved very later because you are not any later.
No, Your Lordship, I haven't
It's
because
for the
bank notices have to go.
you have not given a notice.
No, Your Lordship, we don't have a prior notice system. Your notice has to go. Lordship.
Item number 3.
Okay.
That is relating to protection of river classified. And inadvertently, some documents and some orders have not come to record. So I will say that permitted to form.
When this was filed, that was way back in 2024, or when the appeal is filed,
But we have filed on matter
2024.
But
You
last week,
want that High Court should say where would be your bus stand?
no, what happens in this matter?
That is your prayer.
That there is some technical.
Construction of the bus stand, from the MP lad fund, 3 lakh was
No,
sanctioned.
What happened?
And now you want that the bus stand would be at this place.
No, there, what happened, but the Tahsildar has converted the river into bus stand. And my lord, last occasion, your lordship has put some question that this order, that order has been passed, and inadvertently the petition was not challenged some order in the record. And
The question is, there is an authority I think there is a Land Reforms Act here also.
No, that's
In
not
Odisha.
happening. Because, my lord, your lordship rightly pointed the principles of Alivali and Gilivali. This river is a historical monument, Prachi river. And the in the
River is
assembly,
a
my lord,
historical monument.
my lord, it charge is historical monument. And my lord, 146 crore rupees has been sanctioned in the by the state legislature. And that record has also not been brought in the while answering the revenue minister has stated in 2024.
This land
These
where
are
the
all
bus
the materials
stand,
for proper
where the
argument, my lord, I
proposed
want-
bus stand is going to be constructed.
Ma'am.
This land must have been there in the entry.
My lord,
There
They
must
have
be an entry in the
obstructed the
record of
flow.
rights.
my lord, they have obstructed the natural flow of the water and fill up the river and they are constructed.
You wanted to say it's a reclamation or reclaimed land or what?
There has no authority. It's only the board of revenue or my lord. Which is, I might political because therefore I want to withdraw highly better application.
After arguing for some time, the land council for the petitioner seeks permission to withdraw the petition. The petition is disposed of as withdrawn.
Item number 4.
Yes, we cannot trace out that girl.
My lord, the girl is not yet
Oh.
tested. The present IAC joined before just 6 days.
No, what about IAC?
My lord,
Can you not imagine the plight of the parents?
my lord.
So
The
it has happened for second time.
second time the affair was lost after 1 month.
So what is it doing?
After 1 month of the occurrence, my lord. The occurrence.
What steps have been taken by?
Well, recently the victim has issued a letter. Some days, 4 days required manner to the IAC is also present. And he is undertaking to definitely take the necessary steps to give some time required manner.
That statement is by the. Maybe no, that by the mother. That is the FIR, sir. That is lost by the mother. That my
Affair is lost by the mother.
minor girl who was about 17 years. He has been kidnapped. The FIR has also not been registered yet.
Yes, Lord. Yes, earlier.
Has been registered.
After 1 month,
It has been now.
after 1 month, after applications are given.
I seek your lordship's indulgence to join virtually. With a prayer, just grant me 2 passovers. My lords, I am in the court building. Just 2 passovers, I will be before your lordship to assist your lordship in this case.
They are there for adjournment, my lord.
Just 2 passovers, my lords, I pray.
Why?
Because the conducting advocate, Mr. Sapoti, out of personal difficulty, unable to attend the court.
You are for the petitioner.
Fine.
Mr. Mukherjee, you are for whom?
For the respondent, my lords. For the respondent, I will show to your lordship that the single judge's order has already worked out. This appeal has become infructuous.
Say that Mr. Satpathy has some problem today, he wants it tomorrow. You want it tomorrow.
It can be taken.
Mr. Mukherjee, come tomorrow.
I'll be there. I'll be there before your lordship.
Let's call the next.
Item number 6.
Item number 6, I am for the petitioner. I request for a short adjournment. My learned senior S.K. is not well here. Let it come 2 weeks after.
Why?
My learned senior S.K. is not well here. He has to agree his letter. It's not well here.
When counsel submitted the Mr. Mr. Senior Advocate is supposed to argue the matter on behalf of the petitioner. And he's out of state, the matter will be taken. You want it a week
2 weeks
after?
after.
2 weeks after.
I'm obliged.
Item 7.
Exchange, my lord.
some certified copy I have received and some certified copy.
Madam, this relates to a land acquisition case. So what is the difficulty? Everything has been done.
My lord, no, my lord, they have not issued any notice, my lord. I
What?
have received the reference code, my lord. That is why they are.
That reference court, why you are a requisition body or what? You
I
are
am
claiming an
land-
independent right.
I am land user, my lord.
Correct. So you are claiming an independent right, deholds the other co-sharer.
No, my lord.
What?
No, my lord.
The land was under requisition.
My lord.
It has been acquired.
My lord.
The compensation is determined by the collector. The awarded sum has been deposited. It is paid. It is to be paid or paid to the co-sharer, the recorded owners. You claim that you have a semblance of right there.
No, my lord.
No,
That matter is not.
that matter is not. Then what matter is this?
My lord, your lordship.
On 6 to 2023.
paid, she received the compensation with
No,
protest.
no, no.
With
This,
protest.
he has challenged the order dated 6 to 2020.
My lord.
Right.
Your lordship
6 to,
may see.
just a minute. 6 to 2023, you are not present. That is why since it was a case of the year 2004, this annexure 2 was passed.
This is that case.
Right?
See the.
No, it's all right. Just answer one thing. After this order was passed on 6 to 2023, you have filed an application to recall that order.
No, my lord. In that matter,
That annexure 3 is there.
Yes.
See that annexure 3 is there. And in annexure 3, your prayer is to recall the order dated 6 to 2023. And you have also filed a delay condonation petition.
my lord.
So why have you approached this court?
My lord, the reference code dismissed the said 151 application.
Where is that order?
Where is that order?
That order I have not received.
Then
Because I have challenged the order passed on dated 6 to my lord. 6 to 23. Because without issuing no notice.
Then where is that order?
My lord, your lordship may see. Some of order I have received and some of
I have an
the.
order passed on your application for recalling of the order under section 151 of the code.
My lord.
Where is that order?
That order I have not received, my lord, because I have challenged the main
You
order.
do not challenge this order. That
My lord.
order as well.
Your lordship may see, they have not issued any notice, my lord. And as per section.
that reason you filed an interim application
My
to
lord.
recall the order. And you said that that order has also been passed and the recall petition has also been dismissed. So are you not supposed to amend your writ petition and also challenge the subsequent order which has been passed in that IA?
That order I have to obtain, my lord. My lord, because your lordship asked to obtain the main,
This case basis will
my lord.
for the first instance, or your case was dismissed on the ground that you did not appear, right?
My lord.
You challenge that order not only before this court, but also file an application to recall that order
My lord.
with a delay condonation petition. Now you are saying that in that petition also order has been passed and the IA has been disposed of. That means that order has not been recalled,
Recalled.
right? So are you not supposed to amend this writ petition and also challenge that subsequent order passed?
My lord, because of the lordship asked me to. I will amend, I will
I
amend.
believe my brother
I will amend.
already exercised the advisory jurisdiction.
My lord, I will amend. I will amend, my lord. The lordship.
Please consider, there will be two inconsistent order which would operate simultaneously. Suppose if we set aside the main order, then what would happen to that order where your 151 application was dismissed? It will remain. Then is it not a mutually destructive one?
My
My
lord,
brother was suggesting that
I will
what is
amend.
required under the law.
I will amend.
Please follow that. Adjourn for a week?
Yeah, 2
Yes.
weeks, my lord.
Why?
My lord, some of the order I have not obtained, my lord. Out of,
2 weeks.
my lord.
The Land and Council for the petitioner submitted that though CMA application has been filed in LMS case number 352 of 2004 with a delay condonation application, which has been annexed to this writ petition as annexure 3 and 4. But in the meantime, those applications have already been disposed of, and you want to obtain the certified copy of the order and take necessary steps in amending the prayers to also the writ petition by filing an interim application and 6 for an adjournment, put up this matter after such answer. Yes.
Item number 8.
In the absence of the constitutional GST tribunal, challenge the order of the appellate authority in confirming the demand order issued under DRC 7 under section 74 of the GST Act.
Yes. What?
Your lordships are continuing the liberty notes to come prepared as to whether there could have been a proceeding under 73 or 74.
Correct.
But I had come across there's one notification. It was the notification squarely. Isn't in my. Yes, there's an interpretation which is given to section 74, which was with respect to one of the judgment of the Supreme Court, that the interpretation to section 74 of the CGST Act would be invoked only in cases where there would be material evidence of the suppression of VAT to evade tax on part of the taxpayer. My humble submission to your lordships is, which I could have been proceeded under section 73, but not section 74. The section 74 gives an additional liability of imposing penalty. That penalty is.
Where is the judgment of the Supreme Court?
This judgment of the Supreme Court
in Fiat India.
Case of CCC and HT Bangalore.
Where is that?
I
Simply the authorities have quoted a particular section, section 74(1), and it talks about that this proceeding can only be initiated if for reason of fraud or a willful misstatement or a suppression of the material fact to evade tax. That's the mens rea that has to be shown to evade tax.
With an evidence.
Whatever evidence, or there must be some formation of an opinion must be supported by certain material.
You are not having the citation of this case.
Beg your pardon.
Where is that case?
That Fiat India brand. That is quoted in the very first page, which you just now passed to us.
Not got that judgment. It's a clarification was given.
You attempted to find it out in.
This judgment was essentially on the contract between the.
How can we know that?
Have you done any investigation?
Your lordship, it is not investigation, your lordship, there is suppression, your lordship. So your lordship, this judgment of Honorable Supreme Court, your lordship, the quotation power, your lordship, each case is different.
No.
Your lordship.
I am conscious. That's why I asked that judgment to be brought. Money. Because your authority has simply quoted it
Money.
and then says that cannot be invoked merely on account of a non-payment of GST without a specific element of fraud or willful misrepresentation, misstatement or
Your
suppression of facts to evade tax.
Your Lordship.
Mere misstatement will not do.
Your Lordship.
The intention must be to evade tax.
Your Lordship. Exactly.
So
Your
there
Lordship.
must be some kind of a opinion to be formed.
And it on page 20.
Yes, sure.
Your Lordship.
20.
Your Lordship, the impugned order, the middle portion, the operating portion of is at page 20.
Yes.
This has been started from page 19 of annexure.
Yes.
Your Lordship, may kindly look into the last paragraph. From the work bills, it evidence that the amount of rupees so and so has been received by the taxpayer for the work completed in the pre-GST VAT period. And the said amount is not taxable under GST. Your Lordship, that has been deducted.
Yes.
The taxpayer has disclosed the payment of rupees 10,56,000 taxable value of rupees so and so in the GST at 3B return filed month January and February respectively. In the GST at 3B return filed for the month of March, the taxpayer has reflected the gross value of rupees 24 lakhs as the taxable value. Hence, the taxpayer has reflected the payment from month of January to February and March 2018. But the taxpayer has not reflected the payment received during the month of December 2017 and has suppressed the value. And your Lordship, he has admitted himself. He has admitted himself after issuance of two notices, DRC as per Rule 142(1). Your Lordship, one DRC 01A and DRC 01. He has made payment. So if we have not
Only the question is of a penalty and interest.
Your Lordship,
He has made the actual payment.
not made,
He's not.
not made, not disclosed in the return. All the amounts have been disclosed.
Subsequently, has he paid the entire amount?
Absolutely.
Yes, true. That is what I'm asking. Now it's a question of penalty and interest.
Your Lordship, the provision says, Your Lordship, the provision says, Your Lordship, on the last day I have argued. The provision says if after issue of notice, the tax along with interest will be paid, there will be no penalty. Here, whatever Your Lordship, I kindly look into the table. Where he has paid the tax along with the interest, there we have not levied any penalty. Where he has paid only tax, we have levied interest and penalty. Your Lordship, I kindly look into the table. The two tables, the last two tables, Your Lordship, again after receipt of DRC 01A, you have got it, Your Lordship.
Yes.
And DRC 01, the taxpayer has paid taxes and interest as per the table below. Your Lordship, may kindly look into 8/12/2010. 47,000, the interest penalty 0. He has not deposited any interest, Your Lordship. On 27, Your Lordship, interest he has deposited. Your Lordship, on 20,000, he has paid the interest. So we have not levied in the penalty. The next table, we have levied penalty 0. And Your Lordship, where he has only paid the tax 1,90,129 only tax, we have levied interest and penalty. So the provision is very clear. If you have paid the tax along with the interest, the provision will be contributed there. Your Lordship, may kindly look in the provision.
Yes.
74. Your Lordship, 74(5). Your Lordship, 74(8), Your Lordship. 5 is before issuance of notice.
74A or 74?
5 is the before issuance of notice. After issuance of notice is 74(8). Where any person chargeable with tax and paid the same tax along with interest payable.
You are
under
making
section
74 or 74A?
74, Your Lordship. 74A will affect that
Okay,
from
74.
No, 74 subsection.
subsection, Your Lordship. Your Lordship, may kindly two subsection, 5 and 8.
No, 5 is before the service of notice.
Stop.
8 is after.
Where
So
any
you are
person-
coming under that.
Your Lordship.
Yeah.
So all proceedings shall be deemed to be concluded.
Concluded. Because he has not deposited
Correct.
the total, Your Lordship, hence the proceeding has continued. and the interest and penalty wherever applicable has been demanded, Your Lordship.
Yes.
And against that, Your Lordship, we have filed the first appeal. First appeal has been rejected, confirmed the assessment order. Now he has to, Your Lordship, has passed a similar identical order to deposit 10% and the balance should be considered by the that order, Your Lordship, may kindly pass.
That is what is deposit that.
But may I just answer? That's the seven. I'm not saying, my lords, that I'm not liable for a tax liability. My lords. I'm saying, my lords, 73 could have been invoked
No,
in such situations.
no. If there has been a suppression for 2017, you did not disclose. So there has been a suppression with an intention to evade. Then in that event, 74 will come into play, and the notice was initiated in this.
But see, August 2017 was for VAT period. There was one period which is December 2018.
That has been deducted.
No, that is already deducted.
That was the VAT period. The first one was the VAT period. That period which they say that I had not submitted my, well, it's the statement, the work bills and Form 26 AS. When the notice was issued to me to comply with that, minutes, I had complied with that, and that has also been reflected in their order.
So in that event, deposit that amount.
So here
No,
he
the
has
tax
not
is already deposited.
deposit anything, Your Lordship. Because the 10%, Your Lordship, 10% is only
Because
from
this order
tax.
is amenable to be challenged before the tribunal.
Before the
Since the tribunal is not there,
Yes.
and this is a precondition for
Yes.
maintaining an application.
Yes.
So this order is passed.
Yes.
So that is what you have to do it.
I'll move the tribunal, but the tax is already paid.
This is
So
what is authority. They have to, because this order for tribunal 2A.
So 112, Your Lordship.
100 and
112. One.
Yes. 112.
Your Lordship.
And what is the condition for deposit?
Your Lordship, the condition is only 112.8, Your Lordship. No appeals will be filed unless the appellant has paid in full such part of amount, tax, interest, fine, fees, and penalty arising from the.
And a sum equivalent to 10% of the remaining amount of tax. So,
tax is already paid.
so tax is already paid.
Tax is already paid. So only on penalty and interest.
So why 20% has come?
Your Lordship, before amendment, it was 20%, and subsequent amendment, it became
So
10%.
this is an amendment, and this is a pre-amended period.
Your Lordship.
This is a case of a pre-amended. Then
10%. I am not facing any 20%.
no, 10% is the tax,
Your Lordship.
and the tax amount has already been paid.
No, not required to pay anything. He may not be required to pay anything. Because already entire tax has been paid.
That is what I'm saying.
Yeah,
And so far as a penalty and interest is concerned,
Your Lordship.
that it talks about
Only,
if you come to 8, subsection 8 of section 112,
Your Lordship.
A, what it says?
A is the admitted.
In full, such part of an amount of tax, interest, fine, fees, and a penalty arising from an impugned order as is admitted by him.
Admitted by.
So he is admitting, it's not.
The tax is not
We
paid.
pay the 20%. The rationality has to be done. So 20%
As
or a
your
10%.
as your Lordship pleases.
Let's see. It's the, may I just want to submit one thing?
What?
Let's the, so far the tax amount is concerned, well, let's have already paid the tax amount.
Only
Now
thing
the-
is the interest and the penalty component.
Because the interest and penalty component says that the amount which is in dispute. Because I have disputed the entire penalty and interest amount. That is also recorded.
But
by the
in order to show your bona fide, you have to deposit something.
And the tax has not been.
You are seeking a stay of the further proceedings for realization. Will you not show your bona fide? That you will get a refund ultimately if you win.
Or your Lordship may direct to deposit the entire interest subject to stay of the penalty, subject to payment of the interest. Because interest cannot be disputed, it is automatic in section 50. It is automatic till the date of payment of the tax.
This is what has been done. I think you already.
The interest is liable once you have admitted the tax, means till the date of payment of the tax, from the date of due until the date of payment. It is
So
all
interest component, let them deposit,
your lordship.
and then
Subject to deposit.
so penalty is
Your lordship, let
something
it be
else.
stated.
I think that's yes. The dispute in the instant the writ petition hinges upon the applicability of section 74 capital E of the Central Goods and Service
No, you see 70.
74 of Central Goods and Services Tax Act 2017.
Not capital A, only 70.
Yes, 74.
Yeah.
I got it.
Yes.
74.
Yes.
What I've said. Having invoked by the authority in demand in adjudicating the tax component and thereafter levying the interest and the penalty thereupon. It is a specific stand of the appellant that subsection 1 of section 74 of the said act envisages its applicability in a strict contingencies and or eventualities contemplated therein, and cannot be invoked by the authorities at their sweet will. It, according to the petitioner, at best, the proceeding would have been initiated under section 73, and therefore the action of the authority is liable to be struck down. According to the counsel appearing for the department, the officer, before embarking its journey on the peripheral of section 74, had a material that there has been a suppression of the facts with an intent to evade tax, and issued notice upon the appellant, the writ petitioner. And after taking into consideration the reply having made in this regard, the adjudication was done, which is a subject matter of challenge in the instant appeal. So, according to him, there is an alternative forum to ventilate such grievance. To stop. However, on being asked whether the alternative forum as contemplated under 112 of the said act has been constituted and functional. It is submitted that till date no such tribunal has been established and or constituted. Stop. Our attention is drawn to section 112 within bracket 8. Page 137. 8 of the said act, postulating the mandatory conditions in maintaining an appeal. in the following manner. The quote 112(8) of the said act. A person cannot be rendered remediless the moment the remedy is provided in the statute. Ordinarily, the litigant should not be permitted to jump the forum and approach the writ court. Stop. However, we notice that the said tribunal has not been established and or constituted as yet, and therefore there is no fetter on the part of the writ court in entertaining such writ petition. Keeping in mind the legal maxim, ibi jus, what is this? Ubi jus, ibi remedium. Just find out. I think ubi remedium. Stop. Admittedly, the tax component has already been deposited by the writ petitioner after the show cause notice before adjudication, but before a final adjudication is made thereupon.
Tax and partial interest.
It for certain period, the interest has also been deposited, and the authorities, while passing the final order, have taken note thereof. The disputes simply hovers around the payment of the penalty and the interest. And in terms of the provision contained in subsection 8 of section 112, the full amount of the tax, interest, fine, fees, and penalty arising from the impugned order is required to be deposited subject to the same having admitted by the SSE. So far as the remaining amount of tax is concerned, a sum equal to 10%. In addition to an amount under subsection 6 of section 107, subject to an outer cap, is required to be deposited. The petitioner has raised the issues, and in order to show the bona fide of pursuing such remedy, he has to deposit such an amount as a condition as a condition for stay of all further proceedings contemplated or to be contemplated on the basis of the impugned order. The court must strike a balance between the rights of the parties at the time of passing an interim order. And therefore, we direct how much? 10%?
10% of the interest.
We therefore direct the petitioner to deposit 10% of the interest amount, which is leviable in terms of section 50 of the said act, as within 4 weeks from date. In the event of such deposit within the time stipulated, the respondent department is directed not to act further or give effect to the impugned order or takes any steps thereupon until the disposal of the writ petition. A tribunal is constituted. If the tribunal is there, we can relegate the parties, no difficulty. Then we will not interfere. If the tribunal is not here, then we'll have to adjudicate it. That's why we are keeping it. Otherwise,
In all other cases, your lordship has directed to file when tribunal will be.
that is in anticipation. No, let it be. We'll decide. We'll decide this. Stop. In default of the deposit within the time indicated here in above, the interim order as passed above shall stand automatically vacated, and it is open to the department to proceed in accordance with law, irrespective of the pendency of the instant writ petition before this court.
But it's something to clarify, the order here lordship is dictated after first paragraph, so far as the adjudication order is concerned. This is appeal has been filed against that adjudication, and which has been dismissed. Against that, 112 is applicable. Only one line may be inserted.
I'll see to it.
Yeah, that between there is a gap.
Yes, I'll see to it when
Yes,
it.
yes.
Hey. Yes. Let us come. Yes, call.
Item 9.
Regarding completion of the road and eviction of the unauthorized occupant from the public treatment.
Your grievance in this case.
Well, the grievance is to remove the unauthorized occupant and to complete the road. The road position of the road.
There is already a civil proceeding which is pending. In this case, there is already a civil suit. Oh, this is not a case.
No,
No.
you want the construction to complete the NH 16 from Pahala to Nihali.
And to remove the unauthorized occupant. Only the grievance. That's
So
what
that steps have to be taken. There is
By
a provision in the law.
But they have made representation to the authorities. That is, your lordship will find at page 72.
that will
They have already made representation to the authority. Let that be considered by the authority because no notice has been issued, so there is no instruction available with the authority.
They are the appropriate authority to.
What is this representation you have filed?
At page 72-95. Page 72.
No, that we have seen. What is the purpose of this representation?
Only to that the executive sponsor, the Commissioner of Women's Project, construct and complete the road revenue village Joholo coming under NS 104 under Bhubaneswar Municipal Corporation.
But if there is any obstruction to it, if anybody has encroached the public road, they will take care of it. Why are you filing that petition?
Because you will see the position of the road at my page 56, my lord. Page 56, condition of the road, my lord.
So it may be that some persons are at right place and they have not encroached. So all those things have to be adjudicated by filing appropriate application. By
This is the application, my lord.
Is there not any other provision under 133 CRPC?
No, my lord. Only my lord under the Bhubaneswar Municipal, there is a joint enforcement.
133 CRPC is not applicable to Bhubaneswar. Now the present section that if there is any kind of public
Pursuant to the direction of the honorable court, there is a joint enforcement.
So, own act, National Highway Act. You have your own act.
NH Act.
NH, we are not on NH. Connecting NH to Nirmal.
This is the.
We are not
Not related to NH.
No.
Is a connector.
Connect.
NH to Nirmal.
That is a state. It's a state obligation.
And that is
State obligation, but it is being carried out by the Bhubaneswar municipality.
Yes.
In coordination with the executive engineer of the works department.
Correct.
So
So there is a provision under the municipal act if somebody is occupying
yes,
the municipal premises or the property belonging to a municipality.
but these allegations made in the writ petition,
True.
these are not supported by any.
Oh, I understand, sir.
Yes.
So we'll have to initiate a proceeding.
But
They
if
must
part
be
of-
having a private land. They are the owner of a private land. They cannot be evicted in the garb of this. So it is your duty to take steps.
But so far as the allegations in the writ petition is concerned,
Correct.
these are only allegations made that there are some unauthorized occupation.
But we have to find out whether there is
Yes.
any unauthorized occupants or not.
So that is why. Fine. So that is why I say, since I have not received instruction because this has come for the first time for the fresh admission.
Why detailed particulars has not been given?
Yes.
In which particular land there has been unauthorized?
599, you see page 50.
No, who has encroached? Suppose you said that.
There is a block 4 kilometers. That road belongs to 4 kilometers. There is a batch of persons who are it's not possible.
No, unless you give the
They-
according to you, that
public nuisance eviction of unauthorized occupants.
Madam, there is a joint enforcement committee.
according to you,
Madam,
that they have encroached, but as has been pointed to you,
madam.
that the land might be their own land.
No, madam, because we are giving that, those, page 51, that
By
ROR.
making such type of general statement,
No, no, madam.
that there has been unauthorized encroachment, all these things.
Madam, this is a state highway, specific government,
Identified group,
page 50,
those who have encroached. The allegations are illegal.
not a single person.
This Orissa Municipal Corporation manual, this act also, this public things.
But there is a joint person to the order of the Honorable Court, my lord, earlier. There is a joint enforcement committee constituting OP number 2, 3, and 4. That's why we are giving representation to them.
And the others is looking at the public premises eviction.
And it is common to the smart city.
Where the public premises means any premises situated within the municipality as well.
Right.
So I do not know, under the municipal also, there must be some provisions.
There is also a OPLE Act, Orissa Prevention of Land Encroachment Act.
Yes.
Now, here, my lord, what has happened? Here, the tender has been awarded. Work is in progress. Now, these particular villagers, they have come forward making allegations that.
That I understood it.
Yes.
Sir, somebody may come and say that there is an unauthorized occupants
Yes.
who are occupying.
The authorities have to find out.
Anybody, any possession is a 9/8 principle of time.
Right.
Correct? Any person who is found in certain position has to be evicted with due process of law.
Due process of law.
So now what is that due process of law?
My lord,
There must be an act, there must be something. The proceeding has to be initiated. This is what I wanted, that there must be an inquiry first.
Yes.
Whether he is an unauthorized occupant or
Yes.
not. And secondly, if he is, then what is the remedy that is provided to the act? You have to activate.
The authorities have to first come up
instruction in this regard and submit to us that shows that there is any semblance of truth in their allegations.
Yes, that I.
If there is, then the steps have to be taken. You can't permit those squatters to remain and put a hindrance to the larger public interest.
But this is the over. I'll obtain instruction.
What?
That's a cover matter for the regulation. But public streets and roads cannot be occupied.
No, no. What you are having in your
That decision I got for
What
2
is
years.
this?
I am not sure.
Authorities should first come out with a finding that
Finding.
there is an encroachment.
That is
Then
correct.
the process of eviction will be initiated.
the public interest litigation is at the behest of the petitioners, flagging an issue of the issue of illegal occupants over the government land, creating impediment in construction of a connector to a national highway.
State highway. This is state highway.
State highway.
State highway.
Connected to a state highway or a
From
national
national
highway?
highway. From national highway to near Madam, that 4 kilometers are declared as a state highway.
Oh,
On the
this
Google
is
map.
what I say, that's connecting to a national highway.
Yes. Okay.
That is what we are.
I think my
No, I am sorry.
intellectual is very bad.
I may pardon.
It's a foreign language, don't learn. You want to take it. To a national highway. Mass representation was made to a competent authority.
Annexure 5.
Within the annexure 5. Yet there is no response in this regard. The authorities cannot do such representation is suspended innovation for all time to come and must activate the process of law. So the concern for the state pays for appropriate instructions to be solicited from the concerned department. In view of the above, the state is directed to submit a report on the next date of this day, indicating as to whether there is illegal occupants over the government land where such a road within bracket connector is to be constructed. Also, let this matter be listed up 2 weeks.
Item number 10.
May please. Very innocuous prayer I can bear.
Innocuous prayer.
Yes, one. Lecture 3. Page 18 is my representation. It is collected that since a suit for partition is pending and I am one of the shareholders until and unless that my share is determined.
Obtain an injunction from the civil court.
Because my lord,
I
in
was
view of section 64, in view of section 64 of the Fair
Section 30 reference can be made. There is no difficulty under the Act 1 of 1894. Not under Section 18, I can understand. Section 30, you can. Claiming a right, apportionment of the compensation, you can.
Now,
64 also. 2013.
2013.
New act, it is 64. Section 64.
64.
But my instructions, your lordship, may kindly have a glance.
So it is under the Act 1 or it is under the right to fair compensation.
Fair compensation. Lordship may kindly have a glance for the instructions. In fact, these writ petitions are premature. While a suit is pending, that is a different issue. But here the lordship will look at the preliminary notifications have only been issued. presently under section 11
Of
the
Fair compensation.
this 2013 Act.
13 Act.
Yes,
Only preliminary notifications have been issued.
yes.
Then the process for Rule 15 and 19 has to be done. Then thereafter, the award of compensation will come in section 23.
What is his prayer in this writ petition?
Not to disburse.
Not to disburse the compensation.
Compensation.
The amount has not been deposited. What is the question of
Yes.
disbursement?
Well, that is why I have given your lordship have a glance annexure 4 is one of the notice and one of the
No, sir.
the adjacent
Please kindly consider that they have simply issued a notice under section 11. That is a preliminary notification.
Yeah.
It's still, they have not received any kind of an objection or something like that. They are
that was
in
issued
the process.
That was issued in February
So
2023.
what, sir? Then the collector will have to adjudicate what is the market value of the property. Yes. And if you are not agreed, then
That has already been adjudicated. I don't know what
he
instruction my
says
lord
that it has not been adjudicated.
This is the today's instruction.
That too, but you know, the annexure 4, my lord, one of the one of the landholder, he has already received the notice to regarding payment of compensation. Annexure 4 I have given in respect of the said area.
You can approach them, whatever you
That
want.
is why I have approached the
But
collector.
it does not mean that at this stage, the compensation proceeding or anything has to be stayed. If suppose in a preliminary degree, the court heard that you have no semblance of right, title and interest, who will pay the compensation for this delayed payment?
My simple
You have given your plot number
yes.
in paragraph number 1, and that plot number is 1230, right?
1230.
Now the instruction has come that in respect of that particular plot, only 11-1 preliminary notification has come, and the final the publication has not been made under section 19(1). It has not been issued. So the question of determination of any or payment of any compensation in respect of that plot does not arise. That is what the instruction has been received here.
So it is a premature one.
Because my apprehension is annexure 4, my lord. In annexure 4, some other landowners, they have already been received.
That is in respect of the other plot. You are concerned with your plot.
Yes. That is the reason, my lord, I filed the petition. I filed the representation, then when it was not considered, I have approached this one. Annexure 4 is my apprehension. And in annexure 4, some other landowners, they have already been noticed for that purpose.
कहते हैं ना जो 30 में 80 पिढ़ाई की हुई सदर की बात
What we say on basis of the instruction is being.
Yes, sir. We are quoting this in its entirety, don't worry.
This is.
This petition has been filed for a direction to the opposite party number 224 not to disperse the land which is compensation in respect of plot number 130 and chapter number 165 place for here. He is general civil food place so the disposal of these two. And alternatively, for a direction to the collector to consider the implementation of by annexure 3. Prevent counsel for the state has already the instruction received from the land acquisition officer is located in 2024, in which it has been stated as follows, for paragraph number 5 and 6. In view of
So instruction received, we consider this rectification to be pre-matched. That would be the same in this.
Also said the people are liberty to raise this.
It will be taken on record.
Connected matter also. Connected matter also same. Sub-item 3668. Same.
Item 11.
But last petition was directed to, so the documents, so whether I have approached the collector, so that is, but today I have filed the amendment petition.
When is your application for amendment?
Yes, ma'am, just,
Has it been listed today?
no, but I have to file it. Counter.
There was a direction on the earlier.
Yes, today I prepared here,
File an application for amendment.
today. Tomorrow I will file today. Counter. Tomorrow today I have to file.
Item number 12.
No,
Items you sought for here.
No, only thing is that for 70 notice, I don't question the notice. I am liable to pay. I have only prayed for some time to report the amount because my solicitor has duped me. Amount of, yes.
True, that is, you can.
Now-
You can
No.
chase him, you can, do whatever.
That I have done because I have given the FIR, I have lost the receipt, but only thing is that but after receiving the notice under section 73, I have deported some amount. I only pray not to also give me liberty to approach the authorities to not with this penalty, then I will pay
It's
the.
up to them.
Yes,
The
but I-
statute provides.
Yes, but here has to be paid, has to be paid, but they've got a not,
Whether they have got any power to relax.
no, notification is come.
No, that has gone. The time
If they do not have, then
Sir, within the time I have deported some amount, within the time I have already deported some amount, I will approach the also only grant with liberty and dispose of it. That was
It's
only.
an exercise in, this is an exercise in futility. What can be done?
No, sometimes they also not bow down to us and thought of they give the really console.
Can we issue a mandamus?
No, I'm
Do
only.
certain things which is forbidden in law.
No.
How can we do it? How can we issue a mandamus upon them?
No, I'm not saying that you must direct them to do it. I only say, not I do not read application, the observation, the liable, I will approach the authorities, let them consider it.
So that submission is recorded.
And then now they come up with the notifications to.
The counsel for the petitioner submits that his client does not intend to pursue the instant writ petition and wanted to explore and or exhaust the other remedy available in law. In such view of the matter, the writ petition is dismissed as withdrawn. We have already said, explore and exhaust the other remedy.
By approaching the authorities.
That is what is there.
That will not help me.
That is if possible, you go and approach.
Item 13.
Your matters relates to management of the nodal EPs too. Last time I was pleased to direct the state council. Of course,
I mean, you already sought for instructions, they have not received it
We
yet.
want a headmaster of the school.
So what should-
already sought for instructions, letters have gone.
You
One
take
week,
matter,
your lordship, and it will be there.
This is the matter. When it is served upon you, you ought to have immediately taken
It's
instruction.
already written to them also, your lordship. On the last occasion, the letters have gone, but the instructions
when
are
you have
waiting, your
written?
lordship. On 26th, your lordship. 27th of March, your lordship, a letter.
And when the writ petition was served upon you?
On 26th, 5/3, your lordship. 26th, it had come up for the first time, your lordship. On 26th, it had come.
Take instruction. How soon?
Next week, your lordship, on 8th.
Next week,
On 8th. By 8th, your lordship.
8th.
8th.
Put it on.
The writ petition has been filed, is counsel and counsel for the state seeks some time to obtain instruction in matter. This matter on 8th of April 2025.
Item 14.
Item 14, my lord, the matters come for the first time before your lordship. Today I want to withdraw my writ application. What you may begin to the petitioner to file better application with the better particular. Today I have filed.
You want to withdraw?
What you may begin to file fresh writ application.
Why?
So some documents I could not produce.
No, there must be an incurable defects.
No, therefore.
If it is an incurable, then we can, fatal defects. Otherwise, only you can make an amendment and bring those.
Or first letters.
Your lordship, it is the third writ petition. First writ petition has been dismissed. The second writ petition has been withdrawn. Today is the third writ petition.
Again
And I
withdrawn.
think from the pleadings, it is complete. All the documents have been annexed. It is cancellation of registration on complaint fraudulently, which have been obtained by fraudulent fraud. And means I can establish your lordship.
Then file your affidavits.
Not required, your lordship, primarily on the face of the evidence.
Your lordship.
No, evidence you are wanted to rely, they must get an opportunity to look into those documents.
On basis of the read.
Oh, wait.
Your lordship, only on the read. I don't need any further document to establish. From the read, it can be established.
This
Your lordship,
this appears to be a recurring feature.
My lord.
This appears to be earlier for the self-same release, you filed a writ petition and you withdrew it.
Your lordship, kindly see Annexure 9, my lord. Page 45. Here I have challenged the cancellation of registration.
True.
And principal place of business not disputed.
No, what he,
Now your lordship, when your lordship
what the land and council for the department says that you have earlier approached this court challenging this very order.
But I'm challenging.
And you withdraw it.
There is no, I'm
Second time
challenging.
you filed, now you are withdrawing it.
No, I'm challenging the order dated of first March. In annexure 6.
Your prayer shows that you are challenging annexure 9, whether it is
Today.
correct or not.
Today with annexure 9.
Annexure 9 is dated 14/2/2025.
Annexure 9 is dated below 11th March.
Yes, 11th March.
So prior to that, your lordship kindly say, let me submit. Please let me submit.
Please.
My lord,
Please.
page 45, annexure 9 today I am challenging.
Yeah.
No. What is this WPC number 4064 of 2025? What is that?
On the present opinion over 3 had filed a writ application and he has withdrawn. Present opposite partner number 3.
Who is the partner?
My elder son, not my partner.
Huh?
My elder son had approved this honorable court.
What is his relation with the present petitioner? Who is a firm? Is he a partner of the firm?
No,
His elder son.
So far as additional place of business, as per the agreement, I have opted. Now that part he has disputed.
What is your relationship with the earlier petitioner who has filed it?
My lord, so far as 40.
4064 is
4064.
4064, that petition filed by present OP number 3.
What is his relation with the petitioner?
My lord, he is the elder son.
Petitioner is a firm. It is, I am asking, sir, it is a partnership firm or a proprietorship concern, tell us, and then it is a juristic person, not a living person.
My lord.
So please tell me, you are saying son, how a juristic person can have son?
Well, my lord, his allegation is that in Annex your lordship the agreement kind received. Annex 3.
Can I clarify?
This Niranjan and that Kishore?
The Niranjan is the father, this one is the elder son.
Sir, and this Anand Hypermarket,
My lord.
who is a petitioner here,
My lord.
from your cost title, it shows that that's a partnership firm.
My lord.
So there must be more than one person.
My lord.
Who is the other person apart from Niranjan?
That person is the another son's son, grandson. Another son's son, grandson. Bonehela.
How many partners you have in this partnership firm?
So
one or four or what?
So two, another hyper is concerned 2 partners. One is the Niranjan presentation and he is the grandson. My lord, your lordship, kindly say I will clarify in annex. My principal place of business was not disputed. Now I have obtained another place, additional place of business. On that additional place was disputed by the elder, by the elder son present open number 3. On his petition, so was notice was issued. I have given a reply. Thereafter, your lordship kindly see Annex 6, page 37. Annex 6, page 37. Finding page 41, last para, your lordship kindly see. Page 41. Your lordship last para, that is the finding of the GST, your lordship find page 41 last para. Annex 6. Very. After careful revision of the written reply filed by the partners dated so and so, Messrs. Anand Hypermarket, it is considered that none of the contents of taken is satisfying and additionally in this stage without any supporting evidence. Under the above circumstances, you are directed to file an amendment for deletion of the above additional place of business which you have obtained by means of fraud, willful misstatement and suppression of facts within 7 days from receipt of the notice. Now I pay me, Lord. I want to delete the additional place. This is my. You want to delete the additional place. Then there will be no grievance.
Only he can do.
I
As
want
per
to delete.
Rule 19, only the petitioner can do. He can amend, he can delete, everything he can do.
My lord, I want to delete.
Because
Principal-
his son says that I am the owner of the land.
Why not?
I never issued NOC nor I have executed.
So for
the
an additional place
So additional place, you can't avail the one GST number for both.
well, why not? That is your lordship, the GST number, your lordship can see.
So if you want to delete, that is up to him. You go and approach. You wanted a liberty.
Exactly.
Your lordship,
Liberty, sir.
your lordship, annexure 2 can see.
Why you wanted a liberty? You can go and make an amendment and delete it.
Your lordship kindly annexure 2.
What annexure to?
Annexure 2 is GST certificate was issued in our approval.
So they will revive the certificate if you delete it.
Page 25, your lordship kindly see.
Yes.
Column number 5, address of principal place of business. The backside of another one, so and so. This is not disputed.
So he is not also saying no. So once you extended that GST number to another side, saying that it is an additional one, then there was. Your son has gone against you, sir.
Not son, your lordship. There was an agreement. Your lordship may kindly turn to page 22.
Son has gone, says that I have never executed.
Minor, that he had executed.
So the signature appears to be a false.
Minor.
Somebody impersonating. Somebody has done.
Specifically, when he has made the deed, there is a column. The lessee will not sublet the leasehold building to any third party. And after that, the lessee has sublet.
Therefore,
another agreement.
Who is a lessee?
Your lordship, the lessee is page 18. Page 18.
Present petition.
Kishore Chandra Agrawal is the owner of the land.
That is not disputed.
He has given the lease to silicon dealer. Silicon dealer, in that lease agreement, there was a clause at page 23. Your lordship,
Yes.
Page 23, clause number 8.
That is not disputed, my lord.
The lessee shall not sublet the leasehold building to any third party and will not allow anybody to use. Now, what the petitioner has done, that silicon, the lessee, your lordship may kindly turn to annexure 3.
Page 28.
Your lordship, page 28.
Yes.
And sublet to this petitioner Anand Haifa. And now the original owner, so for given a complaint that fraudulently he has done so. And he has filed a writ petition also before this honorable court by showing that the department has not taken any action. And after we have taken the action, he has written the writ and he has filed the affidavit before the officer that you take this action because this has been taken.
So far as additional place of business is concerned, therefore I pray.
He is against principal place.
I will consider.
So far as additional
in a different perspective. What are the conditions which are required to be fulfilled by an SSE to have the GST number?
Your lordship, because he has
the conditions. Statute says what?
Statute, your lordship, so far section 19, rule 19, rule 9.
What it says, tell me. Now I'm going into a very basic. Now tell me.
Though not in specific words, your lordship, I can understand. Though you not very specific.
That's why I'm asking. Yes, please.
Your lordship, rule 19 amendment of registration, because so far as the original registration certificate, there was no allegation, only amendment.
19.
Rule 19.
Yes, what it says.
Legal name, address of the principal place of business or any additional place of business.
Yes.
Where it does not warrant cancellation of registration after due verification, after the amendment within a period of from the date of amendment.
What is required? This is in relation to the amendment of registration. I am talking about at the time of registration. What is the formalities which are required?
I know your lordship, find your lordship, so far only Aadhaar card and PAN card, your lordship, but after that, your lordship, some verification is required.
No verification. Who are you? I'm just asking what is your authority?
Place of business.
Sir, a person is there in occupation, and if you found that the person is in occupation, whether that occupation is an illegal occupation or a legal occupation, who are you to decide? If there is any violation, if there is any violation of the terms and conditions of the lease deed, it is between a lessor and a lessee
Your Lordship.
who has to take steps. So it is a lessor against the lessee can take steps that there was an embargo for creating a sublease. You have done it. I terminate the lease. I make a re-entry and then you go out.
Your Lordship.
That is between them.
But we have allowed the registration by looking into that sublease agreement.
I'm against it. If a sublease is there, I'm against it. Whether it is a legal or illegal. Are you in a position to take a plea? I tell you very frankly why I'm saying there is a judgment and there is a special bench judgment of the Calcutta High Court in this regard relating to electricity. Under the old Act of 1910, Section 12 contemplates about the legality and the illegality of the occupation. But 2003 Act does not contain any kind of a situation. If the only this section says that any person is entitled, who are the persons, owner or occupier of the premises is entitled to an electric connection. Now the question arose, occupier means a legal occupier or an illegal occupier? It was held that the occupier is a genre and you cannot implement something into it, and the electricity authority are not the adjudicatory authority in that. Once a document relating to occupation comes, that's enough.
Only
Here also, he must be there in the place. Whether his occupation is contrary to a conditions of the lease or not, it's a matter between a lessor and a lessee to take care of that.
Yes, Section 29(2) says that.
That is what I'm asking you. What is the conditions for registration?
Taken.
Show us. Condition for registration. What are the conditions?
Yes. Then what are the documents to be filed? Then after verification, section 10 says about the issue of registration certificate.
So what are the documents to be filed?
Yes, sir. Mobile number, email address, number 3 is subsection 3.
Verification, temporary reference to the membership.
Registration certificate.
So what is, where is part B of form GST regulation REG 1? Where is that?
Twenty-five is the procedure.
No, we were looking at rule 8. Rule 8, which prescribes an application for registration. So what is required? These are the things which are required. No difficulty.
That is that must be prepared. Let me
show us.
REC 1, REC.
Yes, part 2.
Part 2. I am holding.
Are you holding this book, Mr.?
Your Lordship, it is a page.
This is we are referring to that
6.228.
chapter 3 registration chapter.
Page 459. Page 4.
Where is that form we want to just see?
That form is
459.
at
Page 459.
6.228.
In this book, it is 459.
Part B.
I'm holding a separate.
This is form GST regulation 1 and part B.
Application for
That comes the
registration.
trade name, proprietorship, unlimited, foreign, others is specified. Jurisdiction.
But that isn't, we are calling for rent agreement.
No,
Your Lordship.
Yes, you will have to come the column 16, serial number 16. Serial number 16 at page 462. You come left hand side. Is the address of the principal place of business.
Your Lordship.
Building number, floor number,
Your
name
Lordship.
of the building, such and such, latitude, longitude, contact information, nature of the premises, owned, lease, rented, consent, whatever.
And serial number 19A is the additional claim.
What?
Same principal place, what are the requirement?
No, this is the nature of the place. It does not. It does not say that you can go into this.
So what's the nature of placements? You have to provide the evidences.
Are you going to decide whether it is a fraudulent one? It is not a fraudulent one. Are you going to decide? You have decided that it is a fraud on the basis of the statement of the son.
Not basing on the statement, basing on the record, Your Lordship. Basing on the evidence.
His son, who is admittedly the owner,
Your Lordship.
he has approached you.
Your Lordship. Yes.
Raised a dispute.
Your Lordship.
That I have not let out.
No, Your
And I have
Lordship.
not given a notice to this.
This evidence. He has given this evidence annexure 1 that this is the lease agreement which has given by me. Your Lordship, basing on annexure 1, Your Lordship, we have determined, or not we have, Your Lordship, we have determined that annexure 2.
And you. I'm asking.
I'm basing on the place of the record, Your Lordship.
Let me decide this question for all time.
Your Lordship.
You are not supposed to, you are not a quasi-judicial authority, nor you are a judicial authority to decide the violation of any of the conditions of the provision under TP Act. Are you?
Your Lordship, so the place of business. So the place of business is
Sir, place of
evidence and place of business is requirement.
Sir, sublease agreement is produced before you.
Your Lordship.
Let us take a worst case like this. A sublease agreement is produced showing that I am a lessee in occupation. I have sublet to this person. That's the place of business.
Your Lordship.
That shows. Now it appears that the lessee was not conferred a right to sublet by the lessor. Who are you to determine? The lessor may waive his right of re-entry, forfeiture. May waive a right of forfeiture. May not waive a right of forfeiture.
The landowner himself produced the document and
Then
says
let him go to the civil court. Under the TP Act, it is a lease under the TP Act. Is it not?
Your Lordship.
So,
The subsequent.
so business does not change here. We remain same.
Lordship, I admit this and kindly detail counter. Because Your Lordship, I have to take instruction from the department. But Your Lordship, it is additional place. Your Lordship, I can understand.
Then who are you to say that? If the original place is undisputed,
Your
and the
Lordship.
GST number is given to that, if they want an
What
extra
happens
means they
Your
wanted to use the same GST number at a different place as well.
Your Lordship.
Please consider that.
Your Lordship, as per Rule 19, we cannot ourselves in portal, department cannot amend anything. Only he can do.
Oh, I understand.
Yes.
I am on a larger issue. He can do an amendment now. He says, I want to delete it. I do not want that place to be used with my GST number. I do not want to continue with the business is a, I would say, the decision in despair.
I think
Because you have created a lot of mess. But for future, KNU, this is one example, he has succumbed. Now larger question is that KNU,
I think it
can you deny?
It may
First
not
thing
be
is, can you deny registration? Second thing is, can you adjudicate that this is a fraud? This is a misrepresentation? This is a fabrication? KNU, who are you? Are you a quasi-judicial authority? Are you a judicial authority? It attracts a civil consequences. Can you decide it? It must be decided by the court.
We are not deciding the ownership.
Sir,
We already decided.
sir, what you are deciding,
Your Lordship.
come to your decision last paragraph.
Your Lordship,
What you have said. My question is, are you within your competence to do so? Where is that? This is the last paragraph, page 41.
Your Lordship, the detail.
No, I'm not going into the detail. Please come to this finding. Can you make this finding? I am asking you. Are you competent that you have obtained by means of fraud, willful misrepresentation, or suppression of fact? Can you decide a fraud? It's not a fraud. The lessor has said you cannot sublet it, you have subletted it, violated one of the conditions of the lease. That's all. Is a fraud? No.
Not as per the GST provision, 29(2)(e).
Sir, what is a fraud? What is a fraud? Tell me that he has manufactured the signature of the lessor. He has done something which would come. Fraud means any act, deceitful act with an intent to gain.
When
It's not a fraud.
combined,
He has produced the sublease.
One was there.
He has produced the sublease. That's all.
Annex 1 is there. He has produced the sublease.
That's all. He's not supposed to give anything else. He's not supposed to give anything else. Even a trespasser, he can perfect his starting by way of an adverse position after 12 years, provided the ingredients are there. So, can he not let out? The IR 1968 Supreme Court Bill 620 is a very apt judgment on this. That even a trespasser cannot be thrown out, even if he has no title to support to it.
But that is, we have given one opportunity that you amend. And after that only.
You're not getting
You're not,
where
I'm getting your I'm getting.
not here.
I get it.
Yes, I'll be good. You're saying withdrawing?
No, so I have taken, so far as fraud is concerned, I have taken ground in my.
No, I'm not asking, are you serious in withdrawing? You have already filed.
No, for withdrawing the withdrawal petition, you should deposit something. In the bar council.
How you felt the pulse of a bench? What is your decision? Tell me, should we decide this point or not for all time to come in future? You wanted. So we admit, and then you are withdrawing submission. the counsel for the writ petitioner submits that though his client initially intend to withdraw the instant writ petition, but subsequently withdraws such submission and proceeded to pursue the instant writ petition. The cancellation of a GST certificate is basically founded on the LS fraud, willful misrepresentation or submission of the facts. The facts discerned from the record reveal that the petitioner, the partnership firm, applied for an additional place of business on the strength of a sublease executed by the admitted lessee of the premises with the subleasing. The lessor raised an objection before the authority that such sublease is created in violation of one of these terms and conditions of the terms and conditions embodied in the parent lease, which appears to have been projected as a complete embargo in continuing with the GST registration. Stop. The larger question, the pivotal issue involved in the instant writ petition, though not directly agitated, but incidentally arise, is whether the authority can adjudicate as to whether a deed of lease executed between the lessee and the sublessee is an outcome of a fraud, misrepresentation, misstatement, and or suppression of fact, solely on the basis of the restrictive clause contained in the parent lease. The counsel for the department seeks accommodation in this regard to ponder upon the same. The writ petition is thus admitted, as we find that the seminal point, as indicated here in our, is of a larger public interest. Now, is of a larger interest. This is the matter after.
I may not include application on my business that is not.
It is really an extension.
That
So if the extension is rejected, then the original certificate will remain in the original place.
That is I do not produce that certificate. Therefore, that
one certificate, Your Lordship, and combination of two units. So one department cannot provide.
Was it issued for two places, or it was issued initially for one place, and then they wanted to have it extension?
Your Lordship, in two places.
In one month.
It is additional.
Extension, addition, and now the addition is refused.
Your Lordship. Both refused.
We cannot.
The principal case remained with them. So can you reject that in entirety?
My difficulty, Your Lordship, department's difficulty is that department cannot do anything. Only to reject. Why, Your Lordship? As per Rule 19.
Something more.
As per Rule 19, only he can do. For that reason, on March.
The department, since we have found the prima facie case having made out, the department is directed to provisionally issue the GST at a principal place. For which there does not appear to be any dispute. Subject to, such issuance of the provisional certificate is subject to the result of the instant petition.
Right. Yes.
Item 15.
This is.
Challenge. The recovery proceeding initiated by the assistant authority in attaching the bank account of the petitioner. The petitioner is a educational institution. Institution, private education institution, getting government grants. And is a charitable institution coming under subclause 3AB of section 10 to C the Income Tax Act, which is the income earned by the institution will be exempted.
Yes. You can apply before the authority to have that exemption. Have they granted you?
Yes.
Here the petitioner has challenged the annexure 1 and 2. One is the recovery proceeding initiated by department and the stay of demand. Your Lordship, I may say one guideline issued by the Central Board of Directors.
These are the CBDT circulars.
Right.
%, 15%.
That has become now 20% is revised. It had been laid down that in the case where the outer demand is disputed before the CIT appeal manner. In this case, whenever there was a demand of 3 crores 97 lakhs, prior to that issuing the order, the so-called notice was issued. The assessee has not submitted the return of income for the assessment 2015-16. Neither they have complied the so-called notice, nor they have audited the accounts, nor they have complied any queries, any documents they have submitted before the department. In the meantime, the assessee prefer the appeal before the appellate authority, CIT appeal. Now the appeal is pending. Well, before the appellate
They have not secured the stay order there.
No. So in the meantime, they have approached the department for the stay of demand, and that is the guideline that we issued by the CBDT for a deposit of 20% for the grant of stay.
The demand, the assessor order has been passed where I am not required to file the return for the particular year.
That you can
But I have been
that plea before the
but the
CIT
demand has been
appeal.
raised. That were based before the appellate authority.
You take that plea.
Let's see the page 31 of the assessment order. Page 31.
Yes.
Para 5, deep description of addition. As Income Tax Act 1961, an educational institution should follow the instruction A, income tax return by virtue of 139(4)(c). Every educational institution referred to in subclause whose total income without giving effect to the provisions of section 10 exceeds the maximum amount which is not chargeable to income tax shall furnish a return of income
Therefore, the total receipt of the institution exceeds it shall file a return of income. My lords, ma'am, this provision has brought under the statute only from 1/4/2016, and this relates to 14-15, my lords. Financial 14-15. I am not required to file any return, my lords.
Please try to understand, please clarify this situation. An assessment has been done
My lord,
by an assessing officer.
my lord,
You are aggrieved by an order of assessment.
my lord.
Your contention is that you are not entitled to be charged with the tax as you come under the purview of this exempted institution.
My lord, my lord,
Is it?
my lord,
Under section 10.
my lord.
So you are an exempted institution.
My lord,
Now you have taken that plea before the CIT appeal.
my lord, appeal is pending, my lord.
Now the appellate authority will take into consideration, have to decide.
My lord,
The hierarchical system cannot be jumped. Once you have taken, take that plea there. If the CIT appeal is satisfied with you, he may interfere with the order of assessment. If he is not, then you have further remedy before the tribunal. You can go and ultimately reach to the writ court. Now you have directly reached the writ court.
my lord,
What you want is the stay.
my lord, as you lordship will direct, my lord, after the amendment, I have
Take that plea there, sir.
my lord,
Take that plea there.
my lord, just a minute. My lord, after the
You
amendment,
know
I
from the
filed my
core of the
return.
heart what is the problem. You know what is the problem.
My lord, after the amendment, I have filed the returns and I have been asked to nil, my lords. Not difficult to file the return. Why, man?
No, then you take that. You can't jump.
Lesser amount, my lords,
No,
not
jump the
20%.
border. Now you deposit this 20%. They will not insist
My
for
lord, lesser amount, my lord.
20%.
Not never.
And they will refund ultimately if you win. They will pay you
Some lesser amount, my lord, some million, my lord.
No.
My lord, demand should not have been made, my lord. My lord, the commission exemption has allowed pay application.
For subsequent financial year, you have been allowed. So that's a good ground. You can take it because it all depends on whether your activities during that financial year is the main factor. So they have to adjudicate.
My lord, the commission exemption has directed me to pay 60 lakhs, my lords. That I have failed to pay. That amount I will pay back.
That is now the 20% has come.
No, 20% that was there, my lord. What demand should not have been raised against
60
me.
lakhs will come. 3 crores something is the how much?
Well, the commissioner on exhibition, they have asked for default to 60 lakhs. I think 60 lakhs.
So go and.
Sir, I will pay that 60 lakhs, my lords. Sure. Take no time. Yes, I will pay. I will pay, my lords. That's it. I will pay. I will pay, my lords.
What? Should we record your consent?
My lord.
The pendency of and statutory appeal before the CIT appeals. The writ petition is filed by the petitioner SSC. Sealing the order dated 2/7/2024, passed under section 220 within bracket 6 of the Income Tax Act. According to the petitioner, it being a charitable trust, and gets a grant from the government, is exempted under clause within bracket Roman 3 AB of section 10 within bracket 23C of the Income Tax Act 1961. The demand relates to the financial year 2015-16.
Yes.
Only
15, 16,
15,
19, 20.
And
1920.
And 2019-20.
Well, it is particularly 15-16 minor annexure
This is
1.
what I really find. 15-16.
Yes.
15-16.
15-16.
Yes.
Page number 23.
According to the petitioner, in a subsequent financial year, the petitioner has been extended the benefit of such exemption. And therefore, the imposition of the conditions by deposit of rupees 60 lakhs is illegal, is per se illegal.
Is that ready to pay 60 lakhs?
Then. At the time of moving the instant writ petition, it was submitted by the petitioner that they are ready to comply such conditions. But because of the time having elapsed in the meantime for pendency of the instant writ petition, such compliance could not be secured. The counsel for the department submits the counsel for the department clearly submits that the CIT appeal imposed the condition of deposit of 60 lakhs for stay of the demand pending the said appeal. But since the petitioner did not deposit the same within the time limit set for the if he deposits the same, there is no difficulty on the part of the department in staying the further action to be taken on the basis taken during the pendency of this appeal.
Well, the CIT exemption. CIT exemption.
Said appeal before the CIT within bracket exemption. Hyderabad, should I write?
Yes, sir. Hyderabad.
In view of the stand having taken before us, the time to deposit the said sum of rupees 60 lakhs is extended by 2 weeks from date. In the event of the deposit of the said amount within the times indicated here in above, the CIT appeal within bracket exempt CIT appeal, Commissioner of Income Tax within bracket exemption will take note of the same. And the order passed on 2/7/2024 would remain unaltered except to the extent of the time period within which such deposit is to be made. we trust and hope that the Commissioner of Income Tax within bracket exemption would make endeavor to this will remain unaltered, it will remain, so they know what is this.
That attachment is there, my lord, in the
Only
back.
thing is, we have extended, then automatically it cannot be proceeded with. It's a CIT appeal who will take care of that. Don't worry, why you are apprehensive?
Pardon my lord, to make it honorable mention, item number 42 in the list, that matter was had conclusively and a specific order was passed in court number 1. And the matter is, considering the urgency of the matter, my lords were placed in court number 1 to pass a specific order. The matter, I pray. Well, it's item number 42.
Why are you mentioning just now?
I have taken leave of my lord.
Yes.
I'm sorry, I won't thought. The matter was not likely to raise today. That's why I pray. The matter
You underestimate the pace of the court.
My lord?
Why you are understated?
No. If it reaches, then no problem. But I pray,
Yes,
matter is not likely to raise. So I pray matter may come up tomorrow under heading of
Today, if he reaches, where is the difficulty?
mercy. That doesn't it again I have to destroy my lord. That's why my happiness. That's my happiness.
Someone, a senior advocate will make the mention.
But
Ask somebody, if you are not.
We can move fast, don't worry.
okay, what's your life?
Item 16.
Your Lordship, I may be permitted to withdraw the petition to file liberty to file with a particular. Your Lordship, the limitation has not been covered properly in the petition. There is some.
Petition was a limitation.
Point of limitation. Point of limitation has not been covered properly in the petition.
I could not understand.
First of all, it has rejected the appeal on the ground of limitation. The GST appeal.
You are challenging an order in the petition.
Yes,
That order rejecting the appeal on the ground of limitation, you are challenging this order.
yes, Your Lordship.
So why you doing that?
Some.
Oh, you could not plead properly.
Yes, Your Lordship. Some facts are also missing.
File that memos.
I have already filed them.
Yes.
I have given it to the.
Item 17.
This matter.
Government matter.
Government matter. Yes, ma'am. Yes, good Lord.
Item 18.
My lord, this is a license holder. After the course of license was granted, with effect from 21st of February 2025. Carry forward to the next financial year because the exclusive privilege is a final clause.
Where is the other side? Yes, madam. It's also covered matter.
You are still in the meantime, I don't know if there is any technical consideration or not. This is the notification of 29th of 25. Government has also extended for the period of the 31st of April, 30th of April of the because the renewal was going to be done on 31st of January. Because of short lifting of the.
It is up to April.
Yes, Your Lordship. April 30th.
You have already extended this.
Yes, Your Lordship. And he's also given an annexure 5 and representation to the collector, Your
I
Lordship.
can consider it. So where is the difficulty? Then what is the pursuing?
Difficult
You are already covered by this notification.
Yes, that's it.
Why you are pursuing? Now time has been extended.
That's it. Let me withdraw my application with liberty to.
We wanted extension up to March 25. Now the government has given.
Yes, I may be permitted to withdraw with liberty to further cause of action arise. We will approach with that.
It is a separate cause of action. There is no difficulty. For this cause of action, there is nothing.
The land council for the petition of case. They just want to government. The land council for the petition of survey.
Item 19. Item number 19.
May I pray next week, my lord? Item number 19. I pray to leave this matter next week. Praying for an adjournment, my lord.
Adjournment? Why is that? I think to do it.
Some difficulties were there, my lord. I am not ready properly.
Land council for the petition system. Adjournment will not be this matter.
Item 20. 9th. Item number 20. Item 21.
And here the petitioner is the mother. We want custody of the child. There will be child welfare committee. And on dated
How a breaking lie of this nature, how the Big Court will do it? Because there is a Juvenile Justice Act which is in place.
I will tell the member. Yes.
HP.
I am on behalf of Mr. Patel. Well, this consent decision has filed by the petitioner challenging non-compliance of the direction passed by the Honorable Court dated 7/10/2020 under Annex 1. Lordships and the operative person at Annex 10 Miller for the nature of relief sought for and for the pendency of the LA cases.
I'm appealing for the opposition party.
submit the copy of that order so that it can be disposed of.
My lord, Annexure 2.
My lord, I am appearing for the opposite party, as the alleged contender, my lord. The order of his on has already been carried out, and he has been issued notice to receive the compensation amount.
So that.
And I am also filing the reply of the. I'll file the reply.
Just give it that complaint order.
Let's have, I have given the affidavit.
You are appearing for whom?
And on behalf of the HSF. On
Keep that
I
complaint.
am for union of India.
The Land Council for the opposite party submits that the order dated 7/10/2024 passed in WPC number 288/2026 has already been complied with. And in that connection, he has filed an affidavit. The affidavit is taken on record.
For orders item 23.
That the present document was surrendered on April 19/4/2025. The surrender certificate has been filed in this honorable April 20.
Surrender certificate already been filed.
You should be filing one of entry application that has not been brought on record.
Just since it's a criminal appeal of the year 2011. Where we arranged to prepare the people and then rules and the matter be placed thereafter.
Item 24.
Hello, I am from the appellant. Reactor Bail, I number 9/40/2025. Granted interim bail for 3 months. Surrender in time in the 13/3/2021. Surrender certificate filed.
That is the report also of the Learned Additional Service. And report has been prepared, so we'll get ready for hearing of the criminal appeal.
My lord, surrender certificate in the time the file 13/3/2020.
Ma'am, it's all right. The trial court has also reported that the appellant has surrendered, so there is no problem
My
about that. But since it's an appeal of the year 2017 and paperwork have ready, have you received the copy of the paperwork?
No, my lord.
You receive it and get prepared yourself for hearing, right?
My lord, more than 14 years.
That does not mean that the criminal appeal will not be hard ever on merit. The appeal has to be hard on merit or not. You have not filed any bail application. No bail application is pending now. Right? You have gone on interim bail, you have surrendered. Now.
My lord, IN number 9/40/2025 already filed. 28/3/2025.
That is not in the list.
My lord, next week.
Get ready for the hearing. The surrender certificate, the report of the additional session regarding surrender of the appellant. Stop. Since the paper have been released and it's a criminal appeal of the year 2017. That we added the giving commencing from association paper will be supplied to the land council for the appellant. You have received the copy?
Yes, ma'am.
Yes.
25.
If I mail the appellant is surrender, but unable to produce before lawsuit. One time you given today, you over telephone contact me. Already the land court, advocate also send me to register post.
Right, Mr. Satyanarayana, this one I'm considering for the appellant submission to the received instruction that the appellant after having the 18-day period has already surrendered in the trial court and some more time will be granted to produce the surrender certificate. This matter will be commencing from 15th of this month. You will find the surrender certificate.
Oh, I'm not asking. Yes, 15.
15th of April, we are granting.
Yes.
Item 26.
The offenses are under 376 DA. So we pass the order that notice has to be issued to the parents of the minor girl. So whether that is sufficient?
On the last occasion, Government State Council submitted, the notice has been sufficient.
There's no direction for submission of the through IIC.
My lord, the officer supplied me perhaps the newly constituted file. That file has
Sir, your Lordship, kindly produce order dated 11/2/2025.
That is what is before us. We have seen that.
It has already been the London State Council on the
from the order sheet I found that Mr. Jateshwar Naik issued a letter to the concerned the informant my lord, but office has supplied me the new file my lord, the newly constituted file. Order sheet is not maintained and letters are perhaps
now available in the
my lord, our office letters are not available. It's a newly constituted file my lord. Perhaps that has been missing. And petitioner may be directed to supply the copy of the deposition. We can be.
That is one part. The question is now there are orders have been passed that the notice have been sought on the parents of the victim. Because the victim was a minor girl. It's a case of gang rape. And tell us that whether the notices have been sufficient or and counsel for the Mr. Simon has some more time to write the decision on this warrants which are based in the order again. IA number 147 or 2022. Under this heading of this matter, then come on 21st April 2022.
Item number 28.
Please, Your Lordship. Well, this case concerns recruitment to the posts of assistant professor, teacher education in the discipline of education and study. This is in all government colleges, which is conducted by the Orissa Public Service Commission. The recruitment, my lords, is to be made on the basis of merit to be judged by judged by performance in interview.
Delay has been pointed out.
But there's a delay of about 1 month, madam. There's a delay of about 1 month, madam.
That has to be controlled first.
Well,
You started on the very so that is the whole difficulty.
I'm sorry.
Pass this obstacle. What do you say? What is the ground? What is the explanation which you are giving?
Well, in my IA for condemnation of delay, my lords, I've stated that the commission, after receipt of the order, the commission took some time in obtaining legal advice and then taking a decision whether to file a writ appeal. That is in my condemnation of delay application. Paragraph 2 of my condemnation of delay application.
See, my lord, we have filed a caveat in this case, my lord. The copy has not been served on us. Let the copy be
Serving a copyright.
then I will take instructions.
Yes, sir, right.
Yes, ma'am.
Then I will file the objection to the email. My lord,
30 days delay.
my lord.
What objection? They say that they because of the procedural hazards or the compulsion, they could not. There are a lot of meetings are required from the different officials. That is what
My
the
lord.
case is.
My lord.
Waiting is required, so that is what.
My lord, my condemnation. My lord, may record that if there is an objection.
Number so and so is an application for combination of responsible that there is delay of 31 days in filing this very appeal. Now counsel for the respondent who will declare for combination of after clearing the land counsel for the respective parties going to the government shaping the application. We are inclined to condemn the filing the according to the delays from the high put up this rate for admission on.
Item 29.
On the plea appeal, I'm placing last office and place the bail application for Wilson Mahali. 663 of 24. On the last occasion, I lost the direction to bring the custody certificate and help on health ground and criminal antecedent.
My lord. My lord, criminal antecedent report has come. The petitioner, Bhushan Mahanti, is involved only in this case. But custody certificate and health condition, that has not done. I seek some time. Other accused person are involved.
Moving for that criminal appeal 663 of night. The one that he did petition for studio. So 2015.
Yes, ma'am.
And he is now is about 70 years. So that is what you are to obtain instruction about the health condition and also the custody certificate.
Well, the accused is in custody since 28/3/2016. Thereafter, released.
The submission which was made is 20/12/2015.
No, you can have a glance to the judgment para page internal page 2, running page 9.
This man is what is his name?
The accused number 3, my lord. My lord. Sorry, accused number 2, my lord. Yes, 27, 15.
That means he has already undergone. It may be more than 10 years. 9 years sentence. And this is a 2024 appeal, so we are not likely to take up also in the near future. My board appeals are pending. What is the allegation against you? What is the case?
My lord, on the date of occurrence, while the deceased and his two brothers were in the paddy field, the present appellants or the appellant, they abused and assaulted. At the result of which, at the spot, Balaram Suansia, he was dead, and two persons, Pradeep and Pramod, they were severely injured.
The death of one person.
My lord.
They are all villagers.
Yes, my lord.
The dispute was related to that landed property.
My lord.
No criminal antecedent.
The present petitioner has no criminal antecedent, but as other accused person.
About 70 years.
My lord. Other accused person have antecedent.
We are not taking up other matter.
My lord.
Testimony for Bhushan Mahanti and Want to is an application for the land council for the appellant, submit the appellant in judicial custody since 2015. That's the she has remained for more than 9 years. The land council further submits that petitioner is an exit person and due to dispute for landed property, the occurrence in question has taken place. There is no chance of early hearing of the appeal in the near future since it's an appeal of the year 2024. And the petition is having no criminal antecedent. Their application may be favorably considered. Land counsel for the state has obtained instruction that the petitioner is having no criminal antecedent. Considering submission made by the land counsel for the respective party, the period of detention of the petitioner in judicial custody, absence of any criminal antecedent, absence of any chance of litigation of the application in the near future, are inclined to release the petitioner on bail, subject to conditions that some are involved in any criminal activities. Yes. This is number 663 of the last motion. Another just only this class of 6.
Item 30.
He may have delayed 27 days in filing it.
Yes, sir.
Lordship, I am appearing for the sole respondent in this matter. I am appearing today's let them serve a copy.
Let's start with copy and we delay 27 days. We'll start only the delay confirmation petition. We start the writ appeal also.
No, I'm sorry. Lordship, let the delay be condoned and it will be posted for final hearing.
Have you got a copy of the?
Yes, ma'am. I have.
Again, I'm smart to with an application for the cancellation of the in the we learned how to respond and recognition this solution. So, following the village. We learn how to line is component, each component. We learn how to after that, just how the software will be in the land council for the respondent. Potential for admission.
16. For admission item 31.
No, but that it is very this leads to Shishu. Lately, your lordship, this is a public interest litigation matter relates to development of infrastructure of Sardar Vallabhbhai Patel Postgraduate Institute of Radiatic Measure. One of
the gate, the side gate from this Lalbagh police station side that has opened or not? Or that has been enforced by those.
The enforcement is to be removed and there are to be to open.
When it will be removed? There is already a order being passed in that Patak PIM.
Yes, my lord. I have to take instruction that one.
There are two gates. One is from that Partition river side. The other is from this side. This side has been enforced by from vendors. The Patak Municipal Authority has given them license. So the submission about the destination that I think and give some other destination, but this case has not written. So
So Mr. Nayak was dealing the matter on your lordship division when that has been taken. I have no, but I knew that some steps are being taken to evict them and thereafter everybody.
how can you stop the patients, the doctors, the public from entering. You are closing one gate, one main gate of the hospital, the premier hospital of the state, Sisu Bhavan. You close from one side.
One side.
Allow the street vendors to operate. It's strange. And that is in front of a police station. Lalbagh police station.
Yes, my lord.
And you are sitting silently. Collector was present and the DCP was present. We passed the order.
Well, today I will talk to the collector.
What about the infrastructure inside?
Infrastructure about that we have already in phases.
Because there must be a critical care unit
My
to be set up.
lord has rightly pointed.
We have
My submission before your lordship, the trouble started only because the building on which the Sisu home stands, that does not belong to health department, that belong to R&B department. They have not obtained the, my lord.
I see.
I will permitted to mention some commission I want to make before this honorable report. This matter, my lord, is pending for 14 years. We filed this REIT application in the year 2011. Now we are in 2025. In spite of the your lordship direction on several occasions, the multi also D plus six building, multi also building has not yet been completed. It will be completed by 31st December. Accordingly, the PIO has already communicated the information to the petitioner under the RTA Act. I would like to place the communication of information before this honorable court.
Whom you are representing?
I am representing in REIT application number 28,252 of 2011, Maitri Sansar. Maitri Sansar.
You are appearing for the petition.
I am representing the one of the citizen of the Kotak Road 15832.
Okay.
There are four
REIT applications. Similar.
My lord, the only submission before your lordship, the trouble started when the tax department demanded the approved plan from the Sisu Bhavan. They are not being able to produce the approved building plan, for which their safety certificate has not yet been granted in favor of the Sisu Bhavan, for which the building, the new building which has been constructed has not yet been transferred.
What is your instruction if the building is made complete? Why it is not being made operational till now?
No, it is made operational. And we have
Why are you
filed,
not filing an affidavit to that effect?
26/3/25 we have filed the affidavit, my lord.
Where is that?
That in the I am placing that matter, madam. 26/3/25. The superintendent of
Just
the
a minute.
hospital has filed an affidavit.
Please.
What are the development that has taken place by now?
Please
madam?
wait. We are not getting that affidavit.
Para 2,
Please. This is dated, when it is dated. This is affidavit by the superintendent.
Yes, ma'am.
So and so Cuttack, pursuant to the order
Order
dated
dated 5/2/25.
5/2/25. Sorry, last name. पूरा last name. ये वाला. ये वाला.
The copy of the affidavit has been handed over to us today.
All right. We just want to know. You simultaneously will read. Please see that. Yes, sir. What you have stated?
Page 2, my lord, may be seen.
Page 2, yes.
1, that where to declare this Sardar Vallabhbhai Post-Graduate Institute of Pediatric Shikshu for Cuttack to be an autonomous body empowered.
Leave it. We put a pertinent question to you.
Yes.
That where have you stated that the building has been made operational?
Yes, sir.
Which the building has been made
At
complete.
present, the casual department is running for treatment of
Where is that? Which paragraph, which page?
Page paragraph 4.
Because their instruction is that it has not been made operational. If you say that it has been made operational and it is mentioned in the affidavit, then we'll send somebody to verify. Our registry members will go and see that whether it has been made operational or not. You come to the page number 6 of your affidavit.
Yes, ma'am.
Page number 6 of your affidavit.
Timeline.
Yes.
The administrative and academic block has shifted and functional from 10 to 25. The OPD has fully become optional in the ground floor of a new D6 hospital building.
Just a minute.
Yes.
Please read it out once again.
In the ground floor, yes.
Hospital building with effect from 15 to 25. The pediatric medicine ward has shifted and functional with effect from 25 to 25. The other wards like operation theatre, surgery ward, ICU, NICU, PICU and a newborn ward will also be shifted on the scheduled date on phase manner.
Phase manner means?
The date
They have given August or September.
phase manner.
Just a minute.
Please,
Why you are
listen.
taking so much of time? You have saved till
You
December
just
2025.
shifting thing. You are taking it to 36/2025.
Page 5 will give you in the timeline set for shifting, my lord. Page 5.
No, the
Function of oxygen.
The question that has been put to you by the Honorable Chief Justice is that why so much of time is required once you have completed the building, you are just to shift it from one place to another.
Yes,
and
ma'am.
for that you want 4 months. The same compound.
The deficiency was the proper drainage system was not provided, for which 8 crore was estimated and the government sanction was obtained. Now the work has been given to the CMC miner, Cuttack Municipal Corporation, to make that. Unless the drain system operates fully, the operation of the building will not be possible because we cannot able to discharge the water. So that will be started this month, my lord.
Where have you stated so?
Earlier I have stated so. Here also I have stated.
Drainage work.
But
in
page
page number 4.
That on page 4.
Yeah.
Last paragraph. That on 19/4/2004, the superintendent engineer Cooperative convened a meeting for execution drainage networks of so and so, and said joint meeting they decided to work to be done.
19/4/2004.
24. That was a mistake.
Okay.
By Cuttack Municipal Corporation, Cuttack, and for protection and transport, as per the requisition by letter dated so and so and so on. Accordingly, the OP4 has wrote a request letter to the Commission CMC Cuttack for early execution of the drainage work and complete the same before monsoon by letter dated 18/3/25 with the memo to CMC Cuttack. Copy of letter dated so and so and Superintendent Cuttack, Division 1 Cuttack, and dated as annexed B4 and C4 respectively. So, because money was not sanctioned, that was got sanctioned about 8 crores, and work has been now entrusted to CMC to do it, my lord. And this month,
how much time will you take to do it? Because you have to make it functional. If it is not operational, then what is the utility of constructing?
I have contacted my the city engineer and the superintendent engineer, both in charge of the drain work. They have to start it this month. That is what they are saying, my lord.
The difficulty is that passing a bug from one to another, shirking the responsibility.
Only drain becomes operational, my lord, everything will complete.
So everybody, all the department must act in tandem.
Yes, my lord.
Otherwise, you will not be able to achieve the purpose.
There is no coordination between one department.
That is what is the difficulty.
For sanction of 8 crore, the matter is pending. We took up the issue with the urban secretary, and he also sanctioned 8 crore. And now the work has been entrusted to the city engineer who have to start it.
So
This month,
now monsoon will.
By 20th of March, they have to start it, my lord. But previously, I have Mr. Mahant.
We are now in the month of April. Just we have knocked the door of the April.
But by the end of this year, everything will be complete, my lord. Once the drain is complete, everything will be complete. Because shifting will not possible unless drain is there.
No. But you have already shifted in the ground floor. You have already indicated that some of the wards have. You have shifted.
But the entire floor will shift by the water discharge road, the existing drain that will not take care of, my lord. That is the difficult. So let it come next week. I will call the officers and so by what date they have to complete the drain, I will give you the affidavit.
I will make small information in this case, my lord. It has already been indicated that fire safety certificate has not yet been granted.
Next week.
That is the process, my lord.
The affidavit you have received, give reply.
Go through it. They will come up what progress has been made in this regard. Let them do it. Let us see that how we can accelerate the entire thing.
Yes, but I will not take much time. Only one sentence I will want to make before this honorable court. Until and unless the fire certificate is granted and issued in favor of the SK.SAHOO, the building, new constructed building cannot be shifted.
Because the drainage system has to be done. Fire safety will come definitely when it becomes operational or become functional.
Let them say, let them say.
Unless the drainage system is created, we cannot operate it.
My lord, I am very much obliged. The drainage system, it is stalled at administrative approval stage.
No, that he has said that everything has been done. It has been trusted to the Cuttack Municipal Corporation. The money has already been sanctioned. Everything has come. So he says that let me take a concrete, the instruction. What is done? How far he has been. Let him come to the next week. Let him disclose. And then we'll see to it and what can be done.
Meanwhile, the affidavit which has been handed over to us today, my lord, I will take some time and I will file a reply to that.
This is just not adversarial litigation, sir.
My lord.
You have come up with the PIR.
Yes.
You have come up. It's not adversarial. Any suggestion is welcome.
My lord.
Which will really help the purpose of the city or the country.
My lord, we are as serious as the petitioners. We have to warn that it should be immediate to that. Personally, I will also take over the matter of the officers.
What's the problem?
The order dated 5/20/2025. The Mr. Prabhakar Mishra, Superintendent, SBP Postgraduate Institute of Radiators,
has filed the affidavit, wherein it is indicated that as per the timeline, the administrative and academic blocks have been shifted and made functional from 10 to 2025. And the OPD has fully functional in the ground floor of the new G+6 hospital building, with effect from 15 to 2025. The pediatric medicine ward has shifted and made functional with effect from 25 to 2025. So far as the other wards like operation theater, surgery ward, ICU, NICU, PICU, and liver ward are concerned, that will be shifted by such and such a. The Land Council for the state submits that in view of multi-utility hospital building, the proposal of 8.09 crores for drainage network of SBP EGIT pattern has got administrative approval of the government. And in that respect, the execution of the work has been entrusted to the superintending engineer R&B division number 1, Cutter. And the drainage work is likely to be completed at an earliest. However, Land Council for the state submits that some more time may be granted to obtain specific instruction regarding the period that will be taken for completion of the drainage work, which would be necessary for making the building fully operational. Necessary affidavit of the affidavits in that respect by the competent person shall be filed put up this matter.
Ninth.
Next question. 9th of April 2020. And in the meantime, see that the other gate is
Open, man.
from the Lalbagh side.
Item number 32.
To Micros is a letter PI. I have been appointed as a Micros in this matter. Lordship, on the last order 16/7, the state had been directed to file a fresh affidavit. In fact, that's the case where many students have been admitted.
False and fabricated these certificates.
We have filed an affidavit in terms of our direction dated 16/7. In the affidavit, we have enclosed the documents. The secretary school in Massachusetts wrote to all the district inspector schools to give report as against the allegations.
Which is the relevant paragraphs that you have issued later?
For your lordship's convenience, I have brought a brief synopsis.
Just a minute, we just want to see those paragraphs.
Yes. In fact,
That some steps have been taken.
Your lordship is holding the affidavit.
Yes, affidavit filed by one Jyoti Ranjan Misra.
I have brought out those contents of those affidavit of
Just
Is there brief synopsis 2 or 1?
2, yes.
May I please?
Which paragraph you want?
Your lordship may kindly come to page 7. These all the documents have happened.
Just
enclosed.
Page 7 of that affidavit.
Yes. Internal page. Here why the enrollment and students have.
No. This is the affidavit dated 2nd July 2024.
No, my lord. 6/3/2025.
What is that?
16/7 was the order by this honorable court.
Just a minute.
67.
Just a minute.
2024.
Order.
I returned 6.
That is,
My learned says he has not received a copy.
this is not also on the
It's not there on it.
That was e-file. The hard copy is with me, my lord. If your lordship wants to see, I can.
you have to give a copy also to the land and council
My
petitioner also.
In that event, may I pray, my lord, your lordship?
Petitioner, I think nobody appeared. Petitioner to the letter PI, the petitioner, they are not appearing. I think.
In that event, if your lordship will be kind enough to grant me.
No, let us see that affidavit, what you have done.
Yes, ma'am. That will be better.
It's a serious issues they are raising.
Serious allegations.
And several teachers having a fake certificates were found. Have they been dismissed?
Yes. Some teachers who were utilizing fake documents, they got appointment, they have been dismissed.
Dismissed.
Yes, those documents are there.
Yes.
And what about that synopsis, page 2 of my synopsis, your lordship sees.
And criminal prosecution has also been started against.
In one of the lists they have mentioned, after in 17 districts, 89 teachers have been dismissed for fake certificates. And in the another table which they have given, from that it comes out that 230 teachers out of 25 districts, they have been dismissed for fake certificates.
But on the question of that MDM meal, midday meal ballot, that has not been misutilized. The number of students rightly that together.
The allegation of the petitioner was that pretending that there are large number of students admitted in the institution, actually it is a much less number of the students.
In fact,
midday meal was being
correct, man. In fact, the allegation. That inquiry has been conducted by asking all the district schools to give their reports. They have given the report. The students, there is no allegation of any fake admitting any student. Any student by
or fuzzing the figure.
Yes.
Fuzzing the figure of the number of the students.
The first brief synopsis I have filed for your lordship. First brief synopsis, which in fact
talks about
lordship that talks about number of students. 1,72,635 students were identified as fake students.
Okay.
Given the synopsis of the entire data, which they had in fact filed on their affidavit, I produced that in by way of.
So there is no discrepancy in this regard so far as the number of the students are concerned.
Yes.
But the serious allegation is found to be complete. Its found was correct, and you have already dismissed many of the teachers.
And criminal prosecution has also been initiated.
Have you initiated any for recovery of the amount salary has been paid?
That is not in the affidavit because it was filed earlier. I can take instruction as to whether that recovery has been initiated or not. Process of recovery from those teachers.
Have they challenged the order of termination?
Yes, some of them have challenged that. Some of them have challenged before they come to court.
Few writ petitions are pending.
Yes, those petitions are pending. Some of them
single bench or division bench?
Before single bench.
They are not disclosing that.
What is that affidavit dated you have stated?
6/3/2025. You are also for a moment, you are also can see this.
You are not passing it to us, how can we see?
Because the tag has been on that side.
We are asking the office to place it on record. And give a copy to the council.
In course of the day.
Next week. Yes, the land council for the state submits that he has filed an affidavit.
6/3
or by affidavit by whom?
By affidavit by the
Please say
1 week. Affidavit by the Director Elementary Education, Odisha.
Director Elementary Education, Odisha, Bhubaneswar, on 6/3/2025.
Yes.
The same be placed on record. Let a copy of the affidavit be served on the land and council for the petitioner. Matter be placed next week.
9th.
9th.
You not say it comes to the petitioner.
Be served on the land and my cost.
Item note 33.
Mr. Nanda, land now.
This is a matter of being. This is for the cause of the people. Those who are.
But everything was done. That was in a cyclone which was there in 2013. Then the several houses were damaged.
Yes.
And now they have already provided the money in a phase-wise manner.
So
I
that
think
is
3 lakhs rupees was
Given in
That
5
is-
installments.
everybody.
So
No, that is
3,000.
kindly similar. It is boiled down to the order. In the order dated 12/2/2025.
Order dated?
12/2/2025.
Yes.
Mr. Mahathir, Lord Senior Advocate, appears on behalf of the petitioner, submits. There are several people affected by recurring cyclones and super cyclones. The government is seeking financial closure of Odisha disaster recovery project on saying it was.
So only leaving out 613% according to you. They
are
have,
saying
they have already given to 3,047
47,
and leaving out
Leaving out
613.
530.
But
They have said
the
that.
order reflects 613.
Yes, 612, but they have said in the counter that 530. They have
530.
admitted 530.
So what about this?
What that is only I have to explain, my lord. What your lordship said that cyclone is not ended. Cyclone, your lordship must have the knowledge that every year that comes heavy cyclone, alternatively heavy cyclone. These people are in the coastal belt, that is Chilka side, that is 2 blocks of Puri district. Always they are affected. They are poor people. They live in the cottage. They don't have the houses to build. No money. So that is why the design was provided how to make a house so that it will cyclone protected. So that is why under the Odisha disaster recovery project that I have given, the design of the house they have given. So that is why provided 3 lakhs rupees to each of such affected person. So in this way they have already 3,447. They have provided and with 5 installment that is to be given. All installment has not been also completed. But however, they are saying that they will complete it. So far, this 35% are concerned. They are saying that we have provided them that housing scheme under the state, but that is only half of the amount, 1,50,000. And my lord, despite the closure, Annexure 9, which is impugned, your lordship will find a document. I will show to your lordship. The government decided that those who have been provided houses under the state housing scheme, if they have been provided 1 or 2 installment, they have returned back, they will be provided with that 3 lakhs rupees. That is the document, they can do that. So that is my only humble service. So lordship can see that.
Look at it. It's your own document he is relying on.
No, my lord,
If
this is
they
the-
return, then you will include within that particular scheme.
Minor. And another thing, my lord, 55%, they have admitted that landless person, they will be provided house, money, and they will be land and house. That, my lord, I don't have issue. That is there.
Instruction which I
That's
have
it.
received yesterday, your lordship may kindly have a glance to this latest instruction. I'll put this by you of an affidavit, but since I received it yesterday, I could not prepare the affidavit. Lordship may kindly.
No, last time you had said that you have received to file the affidavit. Last time.
There are 2 blocks of the Puri district which were seriously affected. That is Krishna Prasad and Brahmagiri. So far as Krishna Prasad is concerned, I have page mark, that is page number 3, your lordship may kindly see. The report received from the video. With respect to Krishna Prasad, it is found that one beneficiary at serial number 43 of Annexure 5 of the consolidated REIT has already been assisted under the ODRP scheme. 29 number of beneficiaries of Annexure 5 related to Krishna Prasad block placed at serial number so and so of the consolidated REIT petition has been benefited under various rural housing schemes of the center and the state,
including the Pradhan
Mantri Awas Yojana, Special Indra Awas Yojana, etc. Then three number of beneficiaries under Annexure 5 placed at serial number own Pakka houses.
Filed an affidavit.
Because he has said, you said that there are many persons who have not been. And this report reveals that several persons have already been provided the benefits. So you collate those let him come in the form of an affidavit.
They have given the affidavit that 535% pursuant to the direction of the.
Now, the recent one is that they say that they have already extended. So let them come.
Yes,
You mean-
let me verify, let me find.
The land council for the state submits that he has already received instruction in the matter from the collector Puri, and he wants to file the same by way of an affidavit, serving a copy on the land council for the petitioner. Matter be placed, so we can take up next week.
Next week.
10th.
You are submit 12, no, sorry.
12th is a
10,
holiday.
10.
At 34.
On 4th of March, notices were issued on the question of limitation. There are 32 days delay. I think my friend appears for the contesting bank. These are matters relating to area side.
We were appearing for the bank in the before the one single judgment. In the meantime, the bank has been liquidated.
Bank has been
liquidated.
under the IBC.
Cooperative society.
We take instructions.
You have to. Now they have gone. Non-existent.
We'll take instructions regarding.
As a step. We go the NCLT or it's the cooperative. Cooperative. How do you coming up? The thousand for the bank, you are for the.
I have no power. We cannot give a booklet now because the bank has already been liquidated.
That would be for respondent number 4.
Previously, you were appearing for
the bank.
Respondent number 4.
The counsel for the bank who appeared in the instant matter. The means that the bank has undergone liquidation in a winding up proceedings and therefore has become non-existent. A order dated 17/1/2025 issued by the Registrar Cooperative Society Orissa is sought to be produced before this court in support of the same. The copy of the said report, the said order is handed over to the counsel for the appellant in court today, who seeks time to take necessary steps. In view of the above, let this matter be listed. Well, after 2 weeks, give a date after 2 weeks.
May I just request that let it be respondent number 4 because there are 3 banks.
Okay, respondent number 4.
Item 35.
35 also same, similarity.
This is the card or OC card? What?
Oscar Bank.
Oscar.
I'm also handing over a copy of the letter to me.
Is same date?
Same.
Of the same date?
Okay.
Is
Item 36.
This is also areas 13 days, my lord.
Have you served the copy on the other side?
Yes, my lord.
Delay? The principal BB Mahavidyalaya, Chandigarh, he has been noticed.
Notice, my lord. My register post.
No, whether the notice is made sufficient.
So neither the AD nor the unserved notice back yet.
You download it from the official website of the India Post.
All these states can be asked to produce the postal tracking report, the registry can be asked to. The registry was released. It appears that neither the AD nor the unserved notice back from respondent number 3. Let the registry obtain the postal tracking report of R3 and matter be placed in 16. Yes, 16. For considering the application for condonation of delay.
Item note 37.
Rejoinder.
No, my notes. Because I need a 3 weeks time to ascertain the situation because my notes OP number 6 who was interested in the job for the completion of the integrated sewage system has averred in paragraph number 4 that the sewage system could not be completed due to not having.
You are opposite party number?
I not some petitioner in person.
I'm appealing the OP number 3.
I'm for the opinion 2.
No, some time was taken to file the rejoinder affidavit.
That is what
So are you interested to file any rejoinder affidavit or not? So that pleading will be completed and we will hear the matter.
Hence, I wish to file a rejoinder and ascertain the factual situation. Because in STP number, in paragraph
You
number.
have taken out a repetition, so you know the factual situation. When they have filed a counter, you know, if you want to file a rejoinder, say that I want to meet those averments. Or if you want to abandon it, waive it, no difficulty. Record that you have waived the right of rejoinder.
I wish to file a rejoinder.
Rejoinder. Absolutely.
You are appearing in person or what?
Yes,
The Mr. Arpit Sarangi, appearing in person, submits that he has received the counter affidavit filed by opposite party number 6.
OP number 3. I am appealing for the OP number 3. Pollution control.
Have you filed any counter affidavit? All the counter affidavits you have received.
Yes.
State also
Received the counter affidavits filed by the different opposite parties. And he intends to file rejoinder affidavit, and for such purpose, how much time you require?
3 weeks time.
3 weeks time. So, 3 weeks.
23rd.
23rd April. 23rd April you will do? 23rd April.
Item note 38.
Yeah, so the alignment of one road without mandate of law, it's transgressing.
You have suffered. You have suffered.
That's it.
What? You suffered a degree.
So let's say I challenge Annexure 1. Annexure 2, let's say.
Realignment has been done because in the master plan, they have already, their case is that they published it, they invited the objection.
No,
everything was done.
That has not been done. Without mandate of law, in
What?
violation of.
How can you say that it is? We have filed a reply to that.
Copy has not been sought on me in spite of.
Counter affidavit.
Counter
What are you
affidavit.
saying?
Counter affidavit has been, in spite of the specific direction.
Please have a copy of you. How can you know also?
I read your counter, that's why I am.
Yes,
I am countering him.
The land counsel for the petitioner submit that he is yet to receive the copy of the counter affidavit filed by the. If the counter affidavit has been filed by opposite party number, please.
4 and 13.
Yes,
4 is the STSC department.
Yes,
and
yes,
13
yes,
is the
yes.
collector.
Yes, madam. 4.
Opposite party number 4. Opposite party number 4. Relate a copy of the counter affidavit, please serve on the land counsel for the petitioner during course of this week.
Yes, ma'am.
Oh.
My lord, counter affidavit not only by 4, 6, 8, 9, and 10 also.
Acha. 4, 6, 8, and 9. Right?
The direction, last order, there is a specific direction that copy has to be solved within.
It's all right. They have not served. They will serve during course of this week. That is the order, right? And go through counter affidavit. If you want to file anything on that counter affidavit, file it.
I'll respond with the
Give a date. 16. How much time you want?
2 weeks.
2 weeks time. Give a date.
17th April.
Oh.
Item 39.
Leave granted on the last date. I'm filing the general affidavit.
I will serve the copy on them.
I'm serving now, in my plan. And I am just relying on their document, nothing more documents, nothing I have attached. Because it is there.
There are certain
This is the procedure.
report.
I know.
This is the certain reports they have relied upon.
But I am relying there on our
The distance have been disputed, everything. Give them a rejoinder, you go through it.
Yes, ma'am.
The land counsel for the petitioner filed the rejoinder affidavit in court today. Serving a copy, and the land counsel for the state will take some time to go through the same. When you want this matter to come?
2 weeks.
2 weeks.
16th.
16.
Item 40.
Two stand to granted region.
Rejoinder affidavit. Land counsel for the petitioner.
In this case, I for Karan Kumar Nag, we sold us election number 1 in this case.
Yes.
He said that I have not filed this writ of this.
That you are the, that's a serious question. Oh, yes, this is where 4 persons have filed. And his signature is also appearing in the Vokalata. He has come up with this affidavit saying that I never joined. I never authorized the prisoner number 4 to affirm this affidavit. I do not want to kill it. So how is signature? It's a serious.
So that is to be not. That is to be ensured. Right, yes, rights.
Yes, now I remember, yes. What you have seen? Who has received the Vokalata? The advocate and record you?
Yes, my lord, advocate.
Yes. Whether all the petitioners they signed the Vokalata in your presence?
My lord.
Yes.
But the different is my lord, one person is.
I am asking you, sir, when you accept the Vokalata is signed in your presence by the parties?
Not in my. No.
No, then how?
Because.
How you receive a Vokalata?
Because in my village, I went there, they filed my lord. Here not in Cuttack, my lord, but my area, my lord is.
Sir, I am asking you, sir, you are the advocate and record. You have filed a Vokalata duly signed by your clients.
My lord.
They signed on the Vokalata in your presence.
Yes.
Now he says that he was not there.
That's
what is your reaction to it?
My this is change of politics, my lord. Due to change of government is not denying to.
Then we are doing one thing, that the signature which is there, we are directing the handwriting expert to verify the signature which is there, and with the signature on the Vokalata, let us come a report. If the signature is tallying, we will not permit him to go merrily from the corridor of the court. If the signature does not tally, then we will not also permit.
Let me forget to the matter. The disputed matter is not.
No, not disputed.
Because
This cannot be accepted.
Deleting the name, my lord.
No, deleting. This is not a simple question of deleting. He has raised a question that I never signed. I'm never interested. I do not know even that I am the petitioner number 1. That's your affidavit. That means somebody impersonating him has signed it. So it's a forced signature. Can a person go scot-free? It's a fraud on a court and a forgery on a court. He will not let anybody go. If he is not truthful, we will take them to task. If he is truthful, then we will not leave the other. His application, right, and the signature appearing in the vocal letter.
On the face of it appears that it is not his signature. The affidavit, have you received that affidavit?
Middle name is not.
Middle name is not there.
Check that. Is different. S is different.
An affidavit.
We have the pattern of. Yes, that record. That is. What? Apology and permitted to withdraw means I do not know. What for you are tendering apology? Then for committing a fraud or forging the signature, for that the apology or what?
not forging. Because he is withdrawing, that's why not take the case.
Have you got an instruction from your other three clients?
But in 6 months, underground, I'll take instruction, but let me forward to withdraw minus.
This writ petition in the nature of PIL has been filed by 4 persons, namely Shukant Kumar Nayak, Champa Munda, Saluram Badara, and Lalit Samant, seeking for following relief. An affidavit has been filed by Shukant Kumar Nayak, dated 4/3/2025, wherein it is stated that though his name has been shown as petitioner number 1 in the writ petition, but he has not filed the writ petition against the opposite parties. Where have you stated that the signature which is appearing in the Wakalatnama is not that of BW Hunt?
Sir, I have not filed.
He has not filed.
I have not filed.
And it is further stated in the affidavit that his name be deleted from the writ petition. On the basis of this affidavit, it prima facie appears that the signature which is appearing in the Wakalatnama, that is of Shukant Nayak, is a disputed signature, and therefore this court thinks it proper to send the signature appearing in the Wakalatnama to be compared with the signature which is appearing on the affidavit filed by the Shukant Nayak to the handwriting expert of State Forensic Science Laboratory, Rasulgarh, Bhubaneswar, to verify and submit a report as to whether both the signatures are of one person or not. The report be produced before us by the Land Council for the state on the next date, which is fixed to 16th for them to go to 16th of April 2025. A copy of the Wakalatnama, Xerox copy of the Wakalatnama, so also okay. The registry shall permit the handwriting expert to take the to peruse the record and take the photographs of the signatures for the aforesaid purpose. The Land Council for the state shall intimate the fingerprint handwriting expert in that respect. A free copy of the order be handed over to the Land Council for the state.
Item 41.
Relating to a illegal sand mine on the Richipilya River. The last date, my lord, state has taken time to obtain instruction.
What is this? What is this illegal mining at the riverbed? The riverbed?
No, my
At the
lord.
riverbed?
From the river.
Or the embankment or a bank?
From the river itself, my lord.
Here, today we have filed today morning. We have e-filed the counter affidavit. I'm serving a copy on my learned friend. Let him go through that. Call it next week.
But can you permit anybody to go for a quarry or to do a mining activity without any permission or a license?
What stand you have taken, Mr. Counsel?
It was prepared by one of my colleague. It's not available today morning. It has been filed.
That shows that you have not gone through that affidavit.
But this affidavit, in fact, prepared by my colleague, and this matter was assigned because of his personal difficulty.
You have not gone through it.
I have not gone through.
Right. You have already filed the affidavit.
Today morning it has been filed. He filed today morning. I am also serving a copy.
That is filed by whom? The opposite party number?
It's filed by OP number 6.
6. Opposite party number 6 is Superintendent of Police. What he has to do? The appropriate should be either the Tahsildar should have been the correct person to file it.
They have furnished a very report. It is not. Today.
What is not? Oh, he said that I'm basing on that first title. Opposite party number 6 has filed the affidavit.
OP number 6, the superintendent of police.
Supposed to. The Tahsildar is the helmet affair of this thing. So if it is going on, please stop it immediately.
PS case has been registered. That is why it has been filed by the superintendent of police.
True, but there should be a constant visual at the spot. Otherwise, you have already registered a case, but the mischief is still done.
Well, case registered, and the mining officer Barampur has also imposed the penalty as per 51(4) of the OMMC rules 2016, and another PS case has also been registered. So
Why penalty? Penalty for what?
Penalty if there is an illegal mining under Orissa Minor Mineral Concession.
I just thought that it is an excessive mining.
Yes.
Or a illegal, total illegal mining or an excessive mining? Tell us.
Total illegal. Let me then. You'll also make keeping to. Tomorrow I'll just go through and apply. Tomorrow.
The land council for the state submits that opposite party number 6 has filed an affidavit today. Let a copy of the affidavit be served on the land council. He has received the land council for the petitioner has received the copy of the affidavit. Let the affidavit be placed on record. However, going through the affidavit, the land council for the state submits that some cases have been instituted by police for this illegal quarrying of sand activities, and penalty has been imposed, which has been highlighted in the counter affidavit. List this matter constant vigil should be made by the opposite party number 6 to see that there is no illegal quarrying of the sand. Yes.
Next week,
10th.
Vehicles, those were used for illegal mining. Those vehicles have already been seized. Yes.
The vehicles have been seized also. Cases have been instituted. Vehicles have been seized. All these things you mentioned, but and also to keep a constant vigil over the.
And a report to that effect has been submitted by the Tahsildar to the collector. That report has already been published. Action taken report is also.
But keep a constant vigil there, so it's there is no recurrence of.
Yes. Yes.
Item 42.
Constant vigil.
If you, my lord, this case has been argued by the Advocate General.
Should not be a recurrence.
Because it has to be argued by the Advocate General, because the violence of certain.
Yes,
nonsense
I'm
that
sorry, I have no objection for the adjournment, but this is the habit. I'm sorry to say, my learned friend, Advocate General, has been taking adjournment for last 10
occasion it is accurate,
And
yes.
every time when the matter reaches, it cannot.
Sir, this is a very important issue. They have flagged.
So let matter come up
He had
tomorrow.
to
I accommodate
go to some cases, my lord.
Tomorrow at 2 o'clock.
Now there are certain checks and balances in this regard.
My lord.
This case of Bombay that has reached to the Supreme Court.
Yeah, man.
2019 volume 3 SCC, probably. There the Supreme Court has taken into consideration certain aspect, the constitutional aspect.
Constitutional aspect. Article 1914
Article 19(1)A, 19(1)G, if I correctly remember.
Oh, I am obliged.
So all were taken into consideration.
I am deeply obliged.
And there are certain checks and balances which are required to be made.
Yes.
That in the garb of this, does not mean that an unbridled power be given to them. And equally, they have to take a responsibility.
Put a complete ban on the dance. You can't do. They are the citizens of this country. You can't
When he can argue, that is
He is coming back on 9th. 12th. He is coming back to 3 cases.
When the learned Advocate General would be available to argue.
He is coming back on 9th. So 10th is a holiday. 12th, 13th. Sorry, my lord. I'll look
at the April.
Sorry, man. 9th he is coming back. Your lordship, man, take it out of 11.
Let it come on 10th. I don't mind.
Can we 15th that week?
Yes, my lord. Yes.
Beginning 15th?
15th.
In the week beginning with the 15th.
Yes, 15,
16, 17, 3 days. When the learned Advocate General will be available.
15th he will be available. Telephonically, I was informed by the Advocate General that he will not be available till 9th. Thereafter, he is coming back. So 15th he will be there.
15th.
But I have an Amrut there. The matter may come up under the heading of to mention because the matter is already.
You have already mentioned. Underestimated the pace of the bench. What can be done? Now your matter is taken up.
In the past session, I observed. I thought I have a matter not released, but
some matters used to take time, Mr. Senior Advocate. So,
but 15.
A mention is made on behalf of the Learned Advocate General that to adjourn the matter for 1 week. This matter on senior advocate Mr. S.K. Gajendra is present. This matter on 15th of April 2020.
And I am to try.
Come, don't worry. 15th.
We'll take care of that.
Item 43.
May I please your lordship? Lordship, I'm permitted to appear through VC lordship. Lordship, I pray for 2 weeks time to file rejoinder.
The land counsel for the petitioner submits that he has received the counter affidavit filed by the opposite parties number 2, 3, and 4. And she intends to file the rejoinder affidavit. And for such purpose, 2 weeks time may be granted. Is this matter 2 weeks?
17th.
Let it come on 17th, ma'am.
Lordship. Grateful lordship.
Item number 44.
In lordship's order dated 19/3/25, I am filing the objection, my lord, to the additional second additional affidavit filed by the office manager 1 to 3, my lord.
Copy has been served.
And I have served the copy, not served to the setting course of the, I'll serve.
You are appearing for bank, you are appearing.
Main party is
You are for the petitioner.
my lord.
Now you have filed the objection to the second additional affidavit.
19/3/25.
You wanted to shift from a particular place.
What do you want now? You want it?
Next week it may come for final. In the meantime, I'll solve it.
It doesn't have any role to play in this case. In this case, shifting of Canada Bank from Andhra
The shifting of Canara Bank, whether the continuation there is viable or not, they have said the Canara Bank has been very kind, says that there will be some kind of a mechanism.
Yes, they are admitted.
By some.
Only municipal, my lord.
So mechanism, there will not be any disruption. There will be a person or an agency who will receive, disburse money, everything will be done.
And they are admitting in their objection.
So what remained here? What remained here?
My lord, VC fund cannot act like a bank.
How can you prevent a bank from shifting if there is no depositor? If
No,
there
my
is
lord,
no,
since last 12 years it is.
so they have said that they will outsource it, which is a permissible.
That is not a ground for a shifting, my lord.
That is what is there. They say the floods, sometimes the connectivity goes for months. Then the electricity is disrupted. The officers cannot live there. They have to travel from a distant place. All this inconvenience. Human resources are very important factor. How the bank will run without the human resource? If the human resources cannot be utilized with full potentials, what he will do? So agency they have said, yes, or the agency they will give. So where is the difficulty? What?
My lord, come next week.
My lord, kindly have a glance on their own petition. That is, my lord, para 10, page 6, my lord.
The bank is not
We are disposing of this writ petition. Nothing.
What remains in the writ petition? The what law you can compel a bank not to shift? Tell me, any legal provision under the Banking Regulation Act, can you show me any RBI guidelines in this regard mandating that you cannot shift? If there is no legal provision, how can you prevent? Yes, I say the service at the doorstep must be there. So they are ensuring the service at the doorstep. Yes, sir, tell us what to do. Yes?
And
why?
Yes, and we are unable to sit there. Because time again they are taking the time. And we are unable to return the gold placed by the.
They may return the gold in our bank also.
They are opposing that could not be shifted.
You cannot say that you return from our bank. This is not your bank. This is everybody's bank. It is not petitioner's bank. It is a bank of the people. So, objection has been filed by the petitioners to the second additional affidavit filed by the opposite party number 1 to 3 in court today. Copy has been served on the land council for the opposite parties. The land council for the petitioner. This matter to be adjourned to next week. So, can it be put on 9th so that this matter on 9th April 2025. This is taken on record for the land.
So no further adjournment.
No.
In that in adjournment.
No further
adjournment. Last
Item number 45.
Please, this is a repetition challenging the action of the opposite parties in recruiting people in semi-judicial positions through outsourcing lawsuit, which is in violation of the scheme under which these jobs are being advertised, and also this is in violation.
Mission Vasalya is a central funded scheme.
It has its own selection process which has been violated, and appointments are being given to positions where judicial role is substantively involved through outsourcing, which has been outlawed by the apex court of this land and also by a judgment of the Honorable Rajasthan High Court. If your lordship desires, I can ask it.
Yes, we are required to file a counter affidavit.
Yes.
Lordship, that in 2 weeks' time, I will file the counter.
This is a serious issue.
We
know the sensitivity of the matter relating to the children, the extension of the benefits. We are very, very much aware of that. So let them come.
Only one prayer that the IMA can be considered because it was slotted for
what in this matter, what interim order can be passed?
Because they are already starting to recruit through this.
Whatever that, if it is found to be absolutely contrary to the provisions, then that will abide by the result. There is no difficulty. Don't worry.
Land council for the state 6 weeks time to file the counter affidavit. Matter will be stated 16th of April 2025.
Item 46.
46. No, they have solved the.
I'll just solve copy of the counter affidavit. Let it come next week.
Not reminder that what was passed that they should file by 25th, but today now that's serving. So
the land council for the petitioner submits that he has received the counter affidavit filed by the state in court today, and he requests 2 weeks time to file the rejoinder affidavit. List this matter 16th of April.
the interim order was still today.
Interim order is there.
Yes.
Interim. Interim order dated so and so shall continue till next. 7/3.
Not 11.
11/3. 11/3/2020. Just check it. Continue till next date. Yes.
Item 47.
Item 47, I was praying in the morning for 3 weeks time to file counter. In the first item, sub item. Second sub item wrongly tagged to the.
Second sub item single matter. Wrongly it has been tagged.
WPC number 3324 of 2024. The Land Council for the parties submit that this is a single bench matter and not connected to WPC number 2351 of 2025. The matter be placed before the assigned bench. So far as 2351 of 2025 is concerned.
And
you
for the
require some
opposite
time.
part number 4, 3 weeks time to file.
Huh?
3 weeks time. File.
3 weeks time to file the counter affidavit. List this matter.
23rd.
I am appealing for an OPG number 3.
Oh, you are appealing for opposite party number? 4 wants 3 weeks time. What do you want to say?
No.
You have filed your counter affidavit. You have filed your counter affidavit.
No.
You don't want to file.
Because the state has.
It's all right. Just the land counsel for the petitioner is present. Please this matter. Give after 3 weeks.
23rd April.
There is an interim order in item number 47.
Yes, madam. Yes.
Item number 47, first item, please verify. And the interim order is extended till the date.
I say I am for the opposite part number 1 not South. In this case, in one of England.
Copy of the writ petition has not been served.
No.
Yes, the land. Let a copy of the writ petition be served on the land council for the opposite party, number 1. In the meantime.
Item 48.
The public interest litigation, my lord. Let's you can see there 1983-2025 orders, my lord. That's we directed the state council to take instruction, my lord. They fact the case, my lord, the opposite party number.
Cultural land is being imposed on.
Enclosed the public road.
Yes, what you say, sir? You ask for an adjournment to take instructions.
Well, let me come next week, my lord.
You have sought for instruction or not?
My lord?
You have sought for instruction or not?
Yes, my lord.
The land council for the state submits that as per the order dated 19/2025. Yes, sought for instruction, but it is awaited and the matter may be taken up a week after you want.
My lord?
A week after you want.
Right.
When you want this matter to be listed, so that
Next
you
week,
have next week, matter to be listed next week.
10th.
10th.
Item 49.
Madam, in this case, the land acquisition compensation was paid. We have already calculated the dues and all that. We have sent it to the accountant general.
Complied with.
We have already sent the matter to the accountant general for sanction. Estimation of the board, both letters have been received by me. That is already here. That calculation there, we have moved it. I have shared even copy. Accountant general has been moved by the additional secretary to sanction the amount so that it will pay.
The land council for the state submits by filing the written instruction receipt from so and so that the order has been complied with.
Not complied with, but as you calculated it.
The
said to
necessary steps have been taken to comply the order passed on such and such date in the WPC number so and so. The later is taken on record. The contempt petition is disposed of accordingly.
Item 50.
Same matter, man.
Same. You give the same.
Same years. We have already sent to accountant general for signing.
So two copies, make it 2 copies so that each case 1 form.